PWD has been occupying my land for the last 10-20 years.
Have you served this thing?
Yes, my lord.
When have you served?
I served them on, I've served all the parties, the respondents. I served them on 7th.
Who is appearing for the state?
Miss Oshima Sheel. I have reached out to her, my lord, but I couldn't.
Appearing now.
She was appearing on the last date. My lord had asked her to appear personally.
Sir, it's a different.
I understand, my lord, but I could not reach. I have served all other defendants. I've also served all of them.
Please serve the notice upon the government leader. There's no government leader now. Please understand the difficulty.
When I permitted to mention, my lord, this is from the court number 25 mentioning, my lord. Matters from court number 25, my lord. It's motion.
Court number 25?
25, my lord. Honorable Justice Rao, my lord, determination is 34. Sorry.
My lord, item number 470, this is that monthly list matter, my lord. I am trying to, my lord, upgrade, but my lord, I have been informed that it has to be reconstructed. Kindly, my lord, passes an order of reconstruction so that
Construction of the writ
of the
petition.
writ petition.
Why?
Lost.
File loss.
Yes, from there. I have the
Who is opposing you?
state government. State government is not there. It
Sir,
is there, 470.
Item
Item number.
70.
70.
Yes.
GP आगे notice आगे হয়ে গেছে।
Mr. Lahiri, do you have copies of that affidavit?
Yes, affidavits exchange, reports. Report দিয়েছিল, yes. There was a writ petition, report and exception, all I have. Mr. Johor Dev, no, Mr. Johor Rai was.
Yes.
Item number 1.
Item 1, I'm pleading for the petitioner, my lord.
But I pay for the bank.
For what? Why to be mentioned?
For fixing. Lord had said that since its senior friend was not available on the previous dates because of his engagement, my lord.
This Mr. Datta allegation against you.
No, not
Yes, yes.
allegation. It's not a, no, kindly.
Healthy allegation.
Yes.
So my lord had fixed today. My lord had said that if possible, my lord will hear out the matter today itself.
But today, some of the matters are fixed. Those are continuing matters. After that, I can take it up. I can pass it over.
But kindly fix a date, maybe next week or this week.
Kindly fixes a date if my lord is otherwise the list.
I have no difficulty, but
Only I do not know what will happen from the next week, because if motions come only will be 1 week, then it will be difficult. So
as it is, this is a motion bench also.
yes, but now the motions are not being taken up.
I see.
That is why I have upgraded those hearing matters.
I see.
So these are all hearing matters from after the new motions from 7. Those are hearing matters.
I see.
So that is why I can take it up after these matters. Because I don't think Mr. Mitro will be taking much time, because his item is the first one. After that,
Well, I think, Willard, since there is a prayer on behalf of the state now, respondent numbers 1 and 2 are the state. But
state as the answering party.
I don't think so. I don't think so.
It's a disciplinary proceeding
Right. Against an employee of the bank.
So the state is
Very well. Very well. Just to indicate. Otherwise, your lordship may fix it in course of this week also, your
the
lordship.
state representing prior to this.
Yes, state was represented.
Oh, Mr. Ghalib was representing. Anyway, but your lordship, Millard, is right that state is not a relevant respondent as
I'm
such.
keeping it tomorrow.
Very well.
The difficulty tomorrow.
Could it be, Millard, could it be next week? Because tomorrow, day after, Millard, I've got a few matters fixed. Maybe next Monday.
Your information, what will happen from the next week? Any information?
No information. Millard, your lordship may subject to the business of the court permitting.
All right.
Keep it made on Monday, subject to the court's business permitting on
Kindly keeps
Monday.
it on Monday, my lord. This employee is suffering for a long time, my lord. Let the matter be heard.
Yes, let it start.
I will not permit your senior to argue. Make yourself ready, you argue. And if you argue, I will not allow Mr. Datta to argue.
Very well. বুঝতে পারছো?
Yes. The learned
The other Millard
was honorable.
I would say honorable because the learned trial court has held that in the absence of cogent evidence, Millard, he has been acquitted under 235 of CRPC.
All right. How much time it will take?
Half an hour, my lord.
Half an hour. All right. Mr. Doctor?
At least, my lord.
Yes.
No, I don't think it would be a 70-page inquiry report. Anyway, let him start. Let him start.
Is my lord fixing a time, my lord?
Huh?
Specially fixed, it will appear because if the motions fail, it will be taken up. If the motions are taken up, then perhaps it has to go after the vacation.
Very well.
Because all these days motions were not taken up.
Definitely.
Only hardly 1 week
Before
left.
the vacation, usually motions are
Yes,
given
because now
precedence.
for this, I'm taking up those hearing matters so that, yes, call the next matter.
I'm grateful.
Grateful.
The time for the petitioner, item number 3 million.
Yes. Who
Given
is
my-
appearing?
For the register lordship.
Yes. Yes.
There is total due of 1,59,000 millionaires. There was total due of 1,59,000 as on 20
What have you challenged in this petition?
sale notice issued in the
Sale
year
notice issued in
2025.
what happened thereafter?
No sale has taken millard. I am intending to pay the due amount.
Petitioner was directed to pay 50,000.
Yes, millard, I have already.
Paid.
Yes, millard. Yes, millard.
When have you paid?
Millard, within the 1 month, millard.
That was direction lordship. You had 1 month. that is
50,000.
Yes,
only
millard.
the
What is
bank-
the balance amount?
1,09,000.
Pay the balance.
Yes, millard.
When?
Yes. Within 1 month, millard.
Within 1 month.
Yes,
So I'm keeping it. Nothing has happened. No sale will take place, I think. So I record your submission. You pay the balance amount.
Yes, millard.
The learned advocate appearing for the petitioner submits that notice, no notice has been issued now. Since no, what is 3? You are appearing. Where are you living?
Same matter.
Same matter.
Yes.
Same order. Yes, next.
Item 4, my lord, I beg to
I
appear.
am appearing on behalf of the HITCO and the rest of the
Yes.
Behalf of the
HITCO lordship.
Lord, I beg to appear for the petitioner.
2 to 5 lordship.
acquisition.
No, my lord.
It's a land belongs to HITCO.
My lord, I'll take.
Since
My lord,
acquisition, they purchase.
He is for the petitioner.
National, the Newtown Development Authority is an essential party, my lord. My lord, due to bona fide inadvertence, I have left him, my lord. I seek
You
to.
have not implemented.
No, that's why I have taken out can 1, my lord. That requires to be served, my lord, upon them.
Can 1.
Can 1.
I'm allowing that.
Yes, my lord. But
Where is can 1? Can 1 is not here.
it's not in the file, my lord.
Not in the file.
Kindly.
You have a copy of that.
Yes, yes.
No,
Can
no,
ask
sir.
can
Well, it was not served, my lord. This can 1 was not served on any of them.
not be. You say that I record your submission that through inadvertence you have left him as a party.
Yes, yes.
So I'm adding.
They
the-
want to get access to the land of the
So
HITCO.
you have you filed this or you have not?
Yes, I have filed them.
Oh, fine, yes. A copy of it.
দেখাচ্ছে হ্যাঁ, দেখাচ্ছে কেন 1টা দেখাচ্ছে এলো না
in number one. Number two, the allegation which I am heavily opposed lordship. Land belongs to HITCO.
Mr. Banerjee,
No.
is there any allegation against NKDA?
Yes, because they are the author.
Otherwise, you have to amend your writ petition. It's better to withdraw then.
No, my lord, there is an averment, my lord.
Honorable is saying that there is no averment.
No. There is a specific averment, and I say that under the statute, my lord, they are the authority.
No,
The
no.
land.
Mr. Banerjee, maybe, but whether the allegations is it
But I-
complete or you want?
Yes, no. It's complete.
There's
It is
no
absolutely
lordship.
complete.
Absolutely. And the land belongs to HITCO lordship.
My lord,
And
the
they
land.
are-
Consider that.
they-
I've only added parties.
Yes, I'm not opposing this.
When?
My lord, any day next week, my lord.
No, lordship, after valuation.
Why?
So I will not be here, lordship.
Next week, entire week will not be
No,
there.
no. আজকেই বলতে পারতাম হাত তুলে লর্ডশিপ, কিন্তু আমি বলতে পারলাম না।
Friday? No.
My lord, kindly fixes a date, my lord. But the affidavit of service be kept on record, my lord.
The service taken on record. Yes.
Let that application be served upon.
আমি দিয়ে দিচ্ছি এক্ষুনি সব।
তুমি দিয়ে দিও, তুমি
সব দিয়ে
with this lordship.
A formal application, otherwise he could have prayed.
Yes, yes.
For oral prayer also I am alive.
Yes,
That is
usual.
Allowed without service.
Usual.
The Banerjee has completed the formalities. They have taken out an
And
application.
lordship, in this thing, lordship, say, there's no
Yes.
such allegation. Anyway, lordship.
Just call the next matter.
Lordship, 1 week after vacation.
Immediately after vacation. Why 1 week? Yes.
I am appealing for the petition.
My lord, I am taking the point of maintainability.
Point of maintainability.
Yes, the writ is not maintainable, my lord.
Yes. What is this?
Now, my lord, if
Railways.
railways. Now, my lord,
Mr. Lady, what is this matter?
my lord, 2 shop rooms were allotted in 1976 to my lord the brother-in-law and my lord the uncle of the petitioners. Now, my lord, those shop rooms, my lord, it was allotted for conducting business of loose tea. That is page 19 and 20B of the writ petition. Now, my lord, subsequently, the allotee asks for change of nature of business. That is sometimes in 1993. Now, my lord, thereafter, the railway served a notice for eviction. We moved, the erstwhile, my lord, the allotee moved a suit in, my lord, 1998, wherein, my lord, all the facts have been, my lord, recorded. May I just place, my lord, the
What happened? Please give the
suit
background.
dismissed. Now, in the meantime, a master circular has come where, my lord, the railway has departed from the usual circular that all existing shop rooms should be auctioned. That is the existing circular. From there, the railways have made an exception for only 1 year. That only for 1 year they will consider the applications of existing shop owners for change of names and for entering into fresh agreements. And there are certain clauses in the circular itself which has been amended, which says that you cannot subsequently give away, you have to do the business, all those
Yeah.
things. Now, my lord, the petitioners
Some relaxation.
relax,
1 year to the existing.
which is
allotment.
continuing, which is persisting now.
Yes.
Now, my lord, the
This
petition
is by way of that master circular.
master circular. Amendment in the master circular. The master circular is of 2022. The amendment is of 2025, which is continuing. Amendment is of October 2025, so it will be continuing till October 2026. Now, my lord, the petitioners are running a bar cum restaurant. The license and excise shops, excise, my lord, licenses are there. Now, my lord, after that, my lord, during, my lord, we had preferred a appeal out of first appeal out of the dismissal of the 1998 suit. That 1998 suit was dismissed in 2015.
In the suit, it was filed against the original allotee
Suit was filed by the original allotee against the railway authorities
for declaration.
for declaration of ownership, declaration of title, which has been dismissed. But there were interim orders and
And the appeal filed by the
appeal filed by the
original allotee.
allotee. Substituted in the meantime. Substituted by
you.
substituted by me, because the petitioners
Who are you?
petitioners before your lordship are my lord, the original allotee died intestate, and thereafter, my lord, the original allotee's mother and my lord had been my lord inserted, my lord, and we are the now originality mothers have also died. Now, my lord, we are the my lord daughter-in-law and my lord the mother-in-law, no mother-in-law, daughter-in-law of the origin of the mother of the, because the estate vested.
Substituted allot.
Yes, the estate vested in the mother-in-law.
Substituted allot.
The estate vested in the mother-in-law of the originality who died intestate, and thereafter, my lord, from there we are. Now, my lord, we have made an application, my lord, for
appeal. You have prepared an appeal.
appeal also dismissed.
Appeal dismissed.
Yes, appeal dismissed in February 2026. Now, well, after dismissal of the appeal, my lord, we have preferred my lord, a representation giving my lord a along with the my lord the area dues of my lord 3,31,000. I'll be praying for consideration of that representation in accordance with the master circular. Now, kindly takes up my lord the master circular first. Or my lord, may I just draw your lordship's kind attention to the documents?
Mr. Lahiri, where is the judgment of the past in the first
First court has recorded everything.
First
20,
appeal.
27 of not of the first appeal. The recording is in page 27 of the my lord suit itself.
You have said the first appeal also stood dismissed.
Dismissed. That the entire judgment is not annexed. I have only annexed the recording part. This is the my lord where everything has been
Not even
recorded.
succeed ex parte, Mr. Lahiri.
No, I couldn't succeed ex parte.
Even ex parte.
Even ex parte. That is okay, my lord. My lord, may I just place it? The case of the plaintiff in brief is that the suit properties are allotted to the plaintiff in such and such 1976 by different allotment. Since
You are
then,
still in possession.
yes. Trade license, excise license, everything. May I just
Madam,
place?
what do you say?
May I place
Consider
the
this
may I
representation
place
in
the master circular? But it has
Let
to
him,
be considered
let
in
him
accordance
exhaust,
with
my
that.
lord, because
in accordance with
no, my lord, it is not. We cannot consider even. Question of consideration even will not arise. I shall say.
Then I,
Let him argue. Let
yes.
him argue.
yes.
all right.
The case of the plaintiff in brief is that the suit procedure was such and such allotted on such and such by different allotors. Since then, the plaintiff has been possessing over the same for the purpose of selling loose tea. Railway administration also provided the plaintiff of such and such electric power supply in the year 1977. The plaintiff is paying the electric current charges and demanded by railway through electric bills. On 3/9/1993, the plaintiff applied before the railway authority for permission from the railway authority for changing his business into hotel business. Suddenly, on 24/9/1996, Railway Authority issued notice asking the plaintiff to quit and vacate the suit premises on or before 31st October 1996. Thereafter, on 30/9/1996, Railway Authority realized license fees from the plaintiff up to 31st/9/1996. 7. After some period, Railway Authority filed an eviction case against the plaintiff, and plaintiff is contending that the eviction case, contesting the eviction case, is not contending. In such situation, different number 2 directed plaintiff number 3 to arrange to disconnect the power supply.
Eviction suit also.
Yes, my lord.
Railways also filed an eviction suit.
Under the my lord, the unauthorized occupants, estate
What
officer.
happened to that?
That is pending. Now, kindly comes to page 28.
Yes.
This court has perused the materials and record in the plaintiff has stated that one eviction case being number such and such is pending. From the documents of the plaintiff, it appears that the plaintiff was allotted a suit property as licensee. Therefore, this court is of the view that the plaintiff cannot get a decree of title upon the suit property as prayed for according to this court such and such dismissed. Now, my lord, in the meantime, kindly seize the master circular.
2000.
Master circular starts from page 29.
Yes.
Kindly comes to page 37, clause 3.1.
Yes. 3.1.
No fresh license 3. No fresh licensing of the railway land for new 3. Just before that, kindly reads 3. Thereafter 3.1.
Yes. No fresh license.
Licensing of railway land for new establishment of shop, religious structures, private school will be granted. 3.1. For existing shops on railway land where rail has expired,
License has expired.
the license has expired or not yet renewed. These shops will be auctioned for grant of license at revised price of 10% of the market value of the land, provided the land is not required for the railways on own infrastructure and development needs. However, existing licensees stroke owners will have a right of first refusal. The rent shall be increased at the rate of 6% per year. License shall be given for the maximum tenure of 5 years. So this was provision of auction. Now kindly comes to the amendment at page 42. Page 42, Lordship, is there?
Yes.
Paragraph 2, yes, this is the amendment. Master circular such and such. Para 3.1a B and B of the note schedule 1, which pertains to auctioning of the existing shops on railway land, has been reviewed in the board's office. Accordingly, paragraph 3.1 A and B of the note under schedule stands amendment and shall now be read as under. The new entering into the renewal stroke entering into fresh license agreements for existing retail shops, etc., not connected with railway working may be permitted with the following conditions. One-time exemption for change in name of the allotee stroke licensee of shopholder may be permitted subject to realization of outstanding dues with 7% simple interest before entering into a fresh agreement, with the condition that the plot stroke shop should not be transferred or sold on power of attorney to anyone in future. The railway land in question should neither be connected with the railway work nor be required for the railway's use in the near future. This is not relevant because the shop is located inside Bajar, Gol Bajar. It's very renowned Bajar there. The shop holder will submit a certificate that the shop is being taken on lease stroke licensing only, and ownership of the land will remain with the railway without any claim whatsoever. Divisional authority will ensure this before entering into agreement. Fresh agreement to be entered upon for renewal of license of railway by all shop holders. The period of renewal of license shall be 5 years. After 5 years, renewal of license of railway not connected with the railway working can be done at the railways level with the finance such and such master policy. Thereafter, my skip over, these are all the renewal, the clauses which will be incorporated. Kindly comes to clause 7. This exemption proposed in para 1 above will be valid for one time availing with a stipulated period of 1 year from the date of issuance of instruction by the board.
Yes.
Outstanding dues are not deposited such and such. Now, my lord, I have made an kindly now comes to page 45 onwards. Page 45 is the mannered liquor license. Kindly sees it is standing in the name of the petition number 1.
Page 45.
45.
Yes.
Standing in the name of the petition number 1, Duke Restaurant cum Bar, ward number 42, plot number GE 2, 2A. These are the two plots. Lordship is there, page 45. Address of the shop, ward number such and such, plot GE2, 2A, Janota Market, Golbajar, Kharagpur Town, Paschim Medinipur, such and such.
Where is your original license?
Original license, my lord, is a very old document.
Have you annexed that?
No, it is not there.
It is there.
It is, I think, yes, sir. My client may
Page
produce that.
20B.
Page
Page
20.
20B.
20B is not the original license, that is the allotment.
No,
That is
yes,
the allotment. That is the allotment.
That should be
That
allotment
the
only.
allotment. That
Allotment,
license.
yes. Allotment is 19.
Not the original that license. I'm
Oh,
asking you that.
acha, acha. Yes, yes. That is 19, page 19 and 20B. Kindly comes to page 19. Lordship is there at page 19. Yes. I thought original excise license.
No, no.
Plot number G-2, Golbazar, loose tea, everything is given. Page 19 is the first allotment. Second is page 20 is the next page. Thereafter, next page is 20B, 2A.
Yes.
Thereafter are the last receipts. Page 21.
So those were allotment was made in the name of Sujan Chakraborty.
Sujan Chakraborty. Sujan Chakraborty
He passed
died
away.
intestate. Yes, I've annexed the death certificates. Kindly comes to page 23 is the death certificate of Sujan
All
Chakraborty.
right. Then after that, what happened?
After that, my lord, mother, page 24.
Any allotment or license in the name
No.
of the mother?
No,
Who is Babun Chakraborty?
Babun Chakraborty is the brother of Sujan Chakraborty.
Yes.
Estate on mother. Mother thereafter expired.
Yes. But
Babun
no,
Chakraborty was looking after. Kindly comes to page 25.
yes.
And thereafter, Babun Chakraborty also expired. Babun alias Bijan Chakraborty,
Yes.
26. And my lord, I am the wife of Babun alias Bijan Chakraborty, and petition number 2 is the daughter of Babun alias Bijan Chakraborty. And my name will be the Babun alias Babun Chakraborty, care of Sujan Chakraborty, will also appear from page 25. Suit papers.
Yes.
The trade license, and I have shown the excise license. The trade license is also there. Those are in the name of the present petitioners.
Yes.
Now, kindly see page 25 also. And thereafter, kindly comes to the excise license.
How could you get this excise license, Mr. Lahiri?
Excise license is not disputed. There are many bars.
How could you get? I'm asking you. If you do not have any right in respect of a property in question, wherefore you will be.
This is the excise license of 1998 and something like that.
How could you get it renewed?
But
Without
it is-
having any authority in respect of the premises
There was.
where you will be carrying on business.
I'm holding, Miller. I was occupying, and there was no dispute with it. There are many shops which
Mere
are being run
occupation.
like this.
Excise license for the purpose of renewal, Mr. Lahiri, you have to produce some documents.
Yes,
with
these
regard-
documents.
yes,
I
with
think,
regard
Miller.
to the
there was-
premises where you are in occupation.
Yes. There was. I
So,
think I think some kind of orders by the suit court. With Mallard protecting. Otherwise, Mallard, I don't know, Mallard. These have been issued. It is there as of today. That is not in dispute.
No. I'm not saying it's not. It's in
And this is
dispute,
Mallard
but
established institution. There are
How
several
could
bars on the
How could
plate.
you get this excise license renewed
Yes.
from time to time to carry on business in respect of a or from a property
Yes.
where you have or your status is disputed?
Now, my status is disputed because I am
Because it is
Mallard.
practically a license.
Yes.
So you cannot claim
But
any
the excise,
heritable right
no,
with regard to that.
from the license. Yes. But
From
Mallard,
the license,
in view of
you
the
do not
fact,
have any heritable right. So unless that is fresh grant is in
yes,
your favor.
that is what I'm saying as of today. That is what I'm praying, because there is a circular, and this circular must have been brought into place, taking into account all these shops.
Yes, madam. But
And my lord, there
want consideration of your prayer in the light of the Master Circular.
here in the amended circular.
Yes.
Amended circular is 2025 circular.
Yes, that is page 42.
Yes, 42.
The light of page 42.
Yes. And
Amendment.
they may give, because fact is I am there. There are other several shops which are there, which are also running. There are bars, restaurant.
Difficulty, Mr. Why the problem started?
Problem started because of the
Yeah.
dismissal of the appeal.
No,
No. Why you went to file a suit?
That
What's
is
the real
recorded.
problem?
I had that is recorded. I had sought for
asking
change
you.
of usage. Kindly see page 27 on 3rd September 1993. The plaintiff applied for railway authorities a permission from the railway for changing his business into hotel business. It was loose tea. So I prayed for change. They stopped taking my lord the fees and they initiated process. But subsequently they have allowed.
Yes. Now, my lord, when one comes to the court, my lord, one should come with a clean hand. My learned friend has just, and my lord,
I think Mr. Lahiri will also not dispute.
yes,
these
this
are not
nobody will dispute. Now, my lord, what my learned friend has done, my lord, he has just annexed the operative part of the appeal dismissal order. The
Operative
appeal
part of the
order passed by the first appeal. In the
First
first appeal,
appeal.
in the first.
First appeal, I have annexed because it is
Yes.
attached.
page.
My learned friend has annexed only the operative part.
Yes.
What is the alt of the program? Page 56 is the operative part.
Operative part. The judgment has not been annexed. And
You
if,
have a copy of the judgment?
yes, I have brought, my lord.
Now, what is there? What is your objection to?
Yes, my lord,
consider-
kindly. Yes. Now, my lord, this is the order which was passed on 10th of February 2026.
It was ex parte.
Expert.
No, this was a
Also.
appeal was not ex parte. In fact, Union of India was
dismissed
being
ex parte.
represented.
Against defendant. Oh,
And,
yes. দুজনের জন্য expert. Yes, you're right.
2 and 3.
Yes, 2.
But the Union of India normally represents both the divisional engineer as well as divisional electrical engineer. So it was not in
Contest against the respondent number 1.
one. Union of India.
Yes. His suit has been dismissed.
Suit has been dismissed.
Yes.
Now-
Appeal has also been dismissed.
Appeal has also been dismissed.
Yes.
Suit has been dismissed on the ground that the proceedings under the Public Premises Unauthorized Occupancy Act is pending, and there is a specific bar under Section 15 of the said Act that civil court will not have any jurisdiction. On the factual matrix also, my lord, the appeal court has also come to the finding that the present petitioners have no locus to maintain the appeal. This has been done. Now, my lord, the proceedings under the PP Act was initiated during the lifetime of the original LOT. And my lord, he had filed the suit because the notice under the Public Premises Unauthorized Occupancy Act was being given. And immediately thereafter, in the year 1998, he had filed the suit. Now, my lord, it is a license which has been given by the railway authorities. He was originally given the license to run a shop of loose tea. Thereafter, my lord, what he has done, my lord, that these persons, my lord, who are in occupation now, they have not only the occupation of the area which was licensed, they have encroached the nearby areas also. So, my lord, and they have expanded it and have established restaurant cum bar. Now, my lord, so long this Babun Chakravarti or Riya Chakravarti or the other petitioner, my lord, they do not have any locus. They do not have any connection with the railways. Now, my lord, one-time change of name can be considered in respect of a person, my lord, who is holding the valid license. Or, my lord, because suppose
The license means
it is not a
renewal also.
renewal also.
Yes.
But for the purpose of person who has been, whose license has been terminated and proceedings under the Public Premises Unauthorized Occupancy Act is pending, my lord, cannot avail of the benefit of master circular. And my lord, this writ petition is a forum shopping. They have lost in suit. After they having been lost in the suit,
Madam, you are on one hand saying suit is not maintainable as per
suit
the-
is not maintainable.
If that is not maintainable, suit has been dismissed. Let us not go
Yes.
into that. Only one thing I want to know from you. Yes, I accept your submissions that he has violated the conditions of the license. He has encroached upon the property, and an eviction proceeding is also pending. Now, after evicting, he will be giving to someone else.
It will be given to someone
By
else, whether it
auction.
will be auction, whatever it is.
Yes.
They have a right to participate. If in the auction they become the successful bidder.
Till now, only one thing.
Yes,
till now that eviction proceedings has not been disposed of.
yes.
So that is still pending. That is what I am asking you. Do you want to impose any conditions upon him for that purpose? If he agrees to that,
No, Milord, I have taken instruction. My clients are not agreeable to renew the license or to change the name in
Under any
favor of the
condition.
petition. They are, yes, till yesterday, Milord, my instructions were that. And if it is so, Milord, Your Lordship will give me an opportunity to file affidavit. He is in possession. I'll take instruction. Kindly keep it on Monday or Tuesday. I'll again take instruction. Because the proceedings under the PP Act are continuing. So during the pendency of that,
I
change of
think
name cannot be given.
under the Public Premises Act is continuing.
Yes.
Any directions will frustrate that proceedings.
Now, my lord, kindly seize the
Because,
content and
if a
purport
direction
of the
is
master.
passed, it's not as innocuous as in other matters directing consideration. Because
Yes,
once the direction-
I have said it is not like that.
Yes, so
Kindly,
in other cases, yes, if a representation is made, but here when proceeding is pending for eviction,
say for instance, I am evicted.
yes.
Say for instance, I am evicted. Then also kindly seize, say
The
as of
lying-
today, I have been evicted. There is an order of eviction.
That is why I asked you.
As of today, there is no termination. There is no eviction
There has
order.
been a termination. Thereafter, only the proceedings have been initiated.
Payments have been made. Huh.
Payment, no, my lord. What he has done, my lord.
There
Madam.
might be something
Why you will
which
stop me?
caused them to be aggrieved, for which they have
Some questions. You have this. My lord,
maybe you have done something for which they have proceeded against you for eviction.
yes.
So let her take instructions. I am keeping it on Monday because an eviction proceeding is pending
Yes.
and you have lost in the suit to protect your possession also. So no interim order can be passed now. So,
Any now kindly seize the master circular. Master circular gives.
master circular is whether
No, amended circular.
yes,
Amended circular
whether
is
it
for persons who are unauthorizedly
I
occupying.
appreciate that, but
No, it does not say so.
whether
that is-
Then
Yes,
why
it does not say
is this saying fresh agreement? One time
it
exemption
does
for
not deal with the case when they have initiated a proceedings, Mr.
no,
Lai.
my lord. If your lordship reads,
Consider letter take instructions
if your lordship reads the circular, the interpretation is for persons who are in occupation. Kindly see,
who are in occupation is one thing.
one time exemption of charges
Time
change.
who are in occupation and who are in occupation and against whom a proceeding for eviction is pending. These two do not stand on the same footing.
But
There
my lord,
lies the distinction because any direction passed directing them to consider in the light of this will frustrate that eviction proceedings.
but because it is their own
But I give
circular.
you liberty in that proceedings. You can make that prayer that authority will consider.
Yes, that can be done.
I
No, my
give
That
lord,
can be done.
that, my lord, kindly.
That can be
I
done.
give you that
They have,
liberty.
they
I
have
think
not
that will be
proceeded.
better.
They have
He will
not
apply
proceeded.
before the state officer.
They have not proceeded, my lord.
They have.
Let them come with the instruction. Yes.
Remain there as it is.
Yes.
No, my lord,
I'll
this
be
much I
praying
can
I'll be-
agree, my lord. I can concede that they can make representation before the state officer.
I'll be praying for let her come with the instruction. I'm not standing in the way, but I'll be praying for interim order in the next.
What
step.
interim order after a suit
Status
has
quo.
no, after your suit has been dismissed, no.
No, my lord, then they cannot evict me without due process of
No,
law.
they are
The
not
proceedings
with the
are
due process.
initiated.
Process is there. Eviction proceeding is there.
Eviction proceedings was initiated because of the fact that I had
So they are
sought
not
for.
proceeding. They are not proceeding, or they are
They
proceeding.
did not
at a-
proceed because the pendency of
They-
the suit.
My lord,
They are proceeding at a snail's pace, according to you. Not proceeding as fast as
yes,
you
because subsequently,
expected
subsequently,
them to proceed.
subsequently,
So
subsequently, they have also
will happen.
granted
let them come on Monday with instructions. Ashok,
Tuesday, my lord,
Tuesday.
19th.
He will not be there.
32,000 matter is there, my lord. 32,000 matter is there, my lord.
Mr. Lahiri learned senior. Might be some of your competitors might have done something. What can be done?
And railways, my lord, are
Yes, Mr. Banerjee.
May it please your lordship, Lord, this is my application.
Milord, item number 6.
It is there, I mean, the Bhannagar police authorities are there.
Milord, item number 6. Milord, am I audible to your lordship? Milord, I am for the private respondent. This was served on us at 6 p.m. yesterday. Milord, it appears this is for an implementation of an order of cancellation of UD.
Mr. Banerjee, one night is sufficient, I think, for you to.
No, Milord, we've also prepared a writ petition. We're
Ready, Milord.
challenging that it's getting filed today.
He, on the flight, sometimes he
That
gets
is why I'm
ready in
saying-
the corridors.
No, Senior Mr. Banerjee will not make fun of me when I'm
Senior
getting
Mr.
virtually down
Banerjee
with
has
fever.
instructed his client to file a suit on an oral agreement so that there is an specific performance oral agreement of lease.
Can it be taken up in the absence of the state? That's the difficulty.
My entire difficulty is today, Mal, I'll tell you what.
What can be done, Mr. Banerjee?
There's a leave and license agreement which has spent its force. I am the lessee under the Bidhannagar Municipal
Milord, over a 2 day,
I have
over
a
a
letter
letter of 2 days, a
I have
license
withdrawn,
for
my
5
lord.
years of Bancharam has been cancelled. A suit
My
has been
license
filed,
in
it's
name of-
pending.
my
I'm
license-
challenging this notice, Milord.
my license, Milord, Mr.
Tomorrow or day after, by
Milord.
then my writ petition will also be there. I'll serve it on Mr. Banerjee.
Fair
And
enough.
we can have it thrashed out together.
It
That's
is
my only request.
I've also filed a writ petition.
I'm filing, Milord, this was served yesterday during course of the hearing on
Then,
Friday.
then
This
after
notice
that,
was
it's
made
not-
over. My writ is ready, is getting filed today.
Can you ask Mr. Dhiraj Trivedi to appear?
Yes, yes, I'll do that.
Ask him to come. I'm passing it over.
Yes,
Milord,
oblige you,
that
Lord.
kindly doesn't pass it over, Milord. Give me a day.
Oblige you,
I'll
Lordship.
file the writ is absolutely ready.
Lord, my
Kindly
petition
keep
is
it
urgent,
tomorrow.
Lord,
I'll
it is
serve the
urgent.
writ, Milord.
Please wait. Ask your juniors to
Be there.
remain.
Look, I'm also down. I'm down with the
I'll
temperature.
request,
I've not been
yes,
able to come to
I'm not
court today.
asking. I'm not asking you to remain, Mr. Banerjee. Ask your juniors to remain.
Yes, yes.
You
No,
may.
if you could, just tomorrow, my lord. I'll file my writ by then. Kindly
Yes.
keep it.
I will be keeping tomorrow. But
Very well,
ask
very
your
well, very
juniors to remain.
Yes,
Very
yes.
well, very well.
Send for Mr.
Yes, yes, Mr. Trivedi.
Yes. Yes.
Oh, my last senior event starts, my lord. Only two facts.
argue.
No, I'll not argue.
Facts.
Only two facts we wanted to point out, my lord. Yesterday he was placing on the order of the appellate authority. Only two facts I'll just point out and I'll not.
Order of the appellate authority.
5 minutes, my lord.
Then Mr. Vitru, I think, is justified.
No,
Saying-
only two facts.
Giving some
No, it's all
reply.
right. He submitted, my lord, that NGA 14 was placed elaborately. Mr. Mitra will deal with that judgment. NGA 14, where, my lord, commercial rate was given.
I will not deal with it in details. My lord is absolutely saturated with this matter. I am sure I don't
But,
want to waste his time.
A submission was made that NGA 14, the land was acquired by the same notification as not this case. But we couldn't point out the particular, it was dealt with by the appellate authority. The page of the order, I'll just point out where it was stated.
Page.
Internal page 15 of the order of the appellate authority.
Please give me the running page of
Running page of my matter is 577, my lord. The
25101.
oh, that is 327.
320.
327. 327.
Mr. Banerjee, you have filed those bunch of, I have asked
Yes,
you
I
to, where is
two-
that?
Order of the complaint, the bunch is there. Order of the complaint authority, order of the appellate. ওইসব T27 minute of the Lordship will not kindly come to minute paragraph 6.1. 1, 2, 3, 4, 5.
Yes.
Minute 1, 2, 3, 4, 5. 6 line from the top, minute. The location is well connected to bank, school, colleges, hospital, market, health center, etc. Claimants have produced a valuer's report which describes all the locational advantages of the acquired land, which includes school, college, hospital, etc. The complaint authority has taken into consideration the valuation of a property situated at adjacent Goragacha Mouja, which was acquired by the same acquisition notification in NGA case number 14 of 2014. We submitted that, but I couldn't point out the paper or the portion of the order, so he wanted to point out that.
So according to you, these all are
Submitted.
for Yes, I think that
Admitted
is not
fact.
disputed.
Admitted
Mr.
fact.
Mitra has not
That is
disputed
My
because in a proceedings, several lands were acquired.
my lord.
Now the
Same
land
notification.
users have filed compensation cases,
Yes.
and it's not disputed. These 92, 14 and 33
Are the
all arise out of the
same
same
notification,
I think Mr. Mitra
which
has
was
also
considered by the competent authority and the appellate authority. This is one thing, my lord. And the last thing is, my lord, there were 2-3 paragraphs where not the lands were compared of NGA 14 and NGA 92 to say that the lands are not of having similar facilities. For that, the authority has considered not the situation as prevailing today, because he went for an inspection and he, my lord, inspected on the basis of the present day inspection. He has compared the lands. But at the time of acquisition in 2013, the position was different. He has said that there is a 25 feet road abutting the land, which is incorrect. I'll just show that from the map, and that's it.
No, I could not follow this.
He has compared the two lands.
Yes.
In the comparison,
14 and your land.
14 and 92, in comparison, he has said given several facilities of the land, which includes a 25 feet road abutting the land in NGA 14. To
Yes.
show the dissimilarity of 14 and 92. That comparison has been done on the basis of present day situation. He went for inspection himself.
But a road, 25 feet
Road
road,
was
that
not there.
that will not-
No, because there was land. I'll show from the map. Kindly take the map, my lord. It's an incorrect finding. It is in the compilation also, my lord, the map. If your lordship sees the map,
Where have we challenged all this?
no, I've stated that. I've stated that. If your lordship sees the map, my lord, in the map, NGA 33 is landlocked, that is recorded.
Yes.
NGA 14 is also landlocked. Kindly see, my lord.
So please show me from the order. If the order has not considered, I cannot
Order
go
has-
to those facts, Mr. Banerjee now.
No,
Please show me from the order.
order, my lord, he has
Or you
said.
have raised that point, it is also landlocked.
No, I have the map was not part of the record. This map was produced by the railway. Map was part of the railway. So while we are assessing the blood,
Banerjee, if you have not raised a factual issue, there are two things.
no, this,
Now,
this,
if
no,
it's
this,
a
this,
point of law, you can raise it at any point of time, even before first.
the comparison was done by the appellate authority. There was nothing in the record, my lord, in the order of the competent authority which says that the lands are different. They have not produced this map. In the order, during hearing, inspection takes place.
Yes.
It is nobody's case. In their appeal, they are not saying that this land has this facilities. It is not their case. But the appellate authority takes into consideration the present day situation, which is contrary, my lord, to the record. So they should have pleaded it. They cannot show that they have pleaded all these things. The advantages which the authority has considered.
Mr. Banerjee,
They-
have you
they-
stated that in the writ petition, in this, yes.
Yes, I'll show
Please
that.
show me
I'll
that.
show that. But before that, I want to show me the map to show the position of the land.
Prior to that, please show
Right.
me the,
Marker.
what is your positive
Marker.
statement?
I'll find.
Then they have to be given an opportunity to deal with that. Say, because this is a factual issue. If that was not considered, you say this.
No, I have stated. If I have not, if
Show
I have
me
not
that.
stated, then I'll not argue. I'll
Show me
show
that.
I'll show that. I'll show that. Because the map is very clear that it is also surrounded by lands.
But if
I'll
maybe,
show
but
that.
if I have not raised that point,
I'll-
you have
I've
not
raised
raised that.
I have raised that one. I'll show.
Facts, can you take a new point, Mr.
Not a new point. It was taken.
Basically a second appeal if you take at that,
No,
in that line.
I say, my lord, that
Basically a second appeal if you
second
take,
I say that this was something which was extraneous, not created by anybody, but the appellate authority has taken into consideration. I'll show.
then you should have taken that point in
Yes,
this. Please show me
Read the worker.
where you have said this. And in the appellate authority's order, anywhere there is a reference of consideration of that map.
I don't think so. So
Then-
it is a document on record.
Then it might be, Mr. Banerjee, there may be, this is a voluminous matter. There may be many documents. If you have not placed that, you may have taken 10 grounds in the in this writ petition. You may have placed only one.
No,
What is the law? You have not pressed the other grounds. That's the law. If you have not pressed,
no,
so you
in
may
the
have
petition,
annexed that.
in writ petition
At
we have
that
stated.
point of time, you may have thought not to place that or not to press that map.
Paragraph 50 of the writ petition, my lord.
Paragraph.
50 of the writ petition.
My
writ petition, my lord.
Oh, your writ petition.
50.
Yes, sorry. It has to be your writ petition.
My writ petition.
Which first volume? Writ petition is one first volume.
First volume. My lord.
Thank you. Then will be of 2 volumes. Without the annexures. I thought the writ petition without the annexures is of 2 volumes.
No, no. Page number 26 of the writ petition, my lord. Yes, sir.
Volume number 1 টা দিন।
Twenty-six, paragraph 50.
50.
50, paragraph 50. 50 and 51. 51 also I have stated that presentable. That's all. Man. They have not dealt with in their opposition.
Thirty-three and 14 both were landlocked.
As apparent from the map disclosed by them. I'm not going to any other document. And we have paragraph 51 also that after conducting inspection, he has considered the present day scenario. Then the 25 feet road comes, provision for a mall comes. In the map, where is the provision for a mall? So this is one of the points. That's not
Mr. Banerjee, you are taking that in reply. Please consider this. What can be done now? Appellate authority also did not raise before the competent authority.
No, competent authority, my lord, we have produced the similar land.
Map was produced at what stage?
Map was produced by them at the appellate stage.
Not also did not. It was a copy was given to you.
So it was to our advantage. The map, the position was to our advantage. We have pointed that out. In the judgment, these things came. This was not argued by them also that there is a 25 feet road. In the judgment, this thing came. So there was no scope for me to controvert before the judgment.
These are all factual things. I am not going to go into all that.
So because in their appeal, they have not taken this point that NGA 14 is better. NGA 14 came subsequently during the appeal additional document. So there was no pleading to that effect, but they can rely on the document. Only
show me that portion which says that that is on the basis of inspection. Where do you find that observation in the appeal court's judgment or the appellate authority's judgment?
On the basis of inspection. He has not mentioned the inspection.
Then where
inspection,
do you get that? Where do you get that?
We have stated in our petition that inspection was conducted. We have stated that inspection was conducted.
Inspection may have been conducted, but Mr. Kaur yesterday was also submitting. I would request you to show me because maybe an inspection was somebody went for an inspection or something. But where is that reflection that on the basis of some inspection this was done?
Must be there in their report, in their office.
Mr. Kaur, you are making allegations against Mr. Mitro. Now your junior has started arguing on facts. Was saying, no, that is in the lighter vein. Mr. Banerjee was saying that from the map, because those similarities and dissimilarities were pointed out by the appellate authority. What Mr. Banerjee has tried to point out is that the appellate authority, after holding an inspection, he proceeded on the basis of the location or the situation of the properties as it existed on the date of inspection, not at the point when the property was acquired. All those, because according to him, though the appellate authority in the order has mentioned,
Lord, we should at all embark on it. Lord, we have challenged the order of the appellate authority. I don't want to go behind the order. I am just showing your lordship the incongruity so far as the order is concerned. I'm not just
so the difficulty was because what Mr. Banerjee tried to point out, he said that was on the basis of that inspection. It was pointed out that there was a 25 feet road abutting that property of 14.
So that is reflected in the order of the appellate authority itself.
Yes, yes, he says that, but he tries to distinguish that by saying that was a position reflected upon inspection.
Lord, let us not get
but
into it.
Not as per the map. He wanted to show from the map that 14 is also landlocked.
Lord, I just want to say this, that Lord, that 20 feet wide road helps me, my property. If he has considered 20 feet wide road,
Mr. Banerjee wanted to say no.
so I am putting it the other way around. I am saying that it is one has to take into consideration the surrounding.
No difficulty. If you want to proceed on that.
No, I accept it.
We don't want to go to the map since Mr. Banerjee was placing reliance on the map for the first time here to go to that might be difficult.
Let us Lord forget about the map. I go by the order of the appellate authority and show Lord that the infirmities he has not followed the law. This has been my submission. I stick to that. Just one factual corrections which I wanted to make. Yesterday, Lord, I could not show from the order of the appellate authority that our project and the project under that 14 of 2014 was the same. This I couldn't show from the order.
Same acquisition proceeding.
Same acquisition proceeding.
That is not
No,
disputed.
but the project was also the same. Kindly, my lord, have a look at paragraph 4.1 of
Project means the same acquisition proceeding.
no, housing project. The housing project.
Yes.
Lord, my submission was that 14 of 2014
Yes.
was given commercial rate because he had a conversion in his favor as commercial housing project.
Bastu commercial, not Bastu commercial.
No, kindly, my lord, Shali to it was housing complex, commercial housing complex.
In your petition or Mr. Mitchell?
No, kindly see the appellate authority's order.
In this matter, appellate authority.
In this matter.
Page.
Lord, starts at page 313.
313.
Yes, kindly come to paragraph 4.1.
Yes.
This is our case. The claimants being the owner of the land applied for conversion of the said land on Sali to housing complex. This is my case. Now, Lord, please come to paragraph. Yes, 6.1.
6.1.
Yes.
Yes.
Kindly, Lord, see after around the middle of that paragraph, there is a figure of 24,26,244.
Yes.
Has your lordship found that?
Yes.
Per decimal, etc. Then, Lord, the sentence. This is so because the valuation of the land has to be assessed based on potentiality of the land, which in the present case is commercial. Such potentiality is not dependent on acceptance of commercial tax. The description of the land in the purchase deed of the respondent as Shali does not reduce the potentiality of the land. Respondents purchased the land as Shali but converted it as commercial housing complex. So in my case, it is housing complex. In 14 of 2014, it is commercial housing complex. Now, Lord, when I build a housing complex, it's not meant for me. It's meant for selling and it's meant for commerce. The conversion certificate will not make the difference. The purpose was the same. This is what I wanted to point out. And I'm sorry, Lord, sorry for, I say sorry to my learned senior. Yesterday I had concluded, but I couldn't find this. I had seen it while reading the order. I had seen it. This shows that I am also aging.
This justifies the prayer of Mr. Mitro made yesterday. Give a reply to reply.
No, reply to reply. I don't say that these facts were there in the order. It's just that I missed it. That's all.
No, you are never sorry to the other side. Why should you be sorry? You are discharging your duty to your client. So you are entitled to do whatever is necessary to do that without misleading the court.
And that's right. Yes, Mr.
Mate, please. I shall be very short. Well, I take your lordship first to, my lord, the order of the competent authority in the other matter in 14.
14.
Yes. That, my lord, your lordship will please to find in volume 4.
Or placed yesterday.
Yes.
Which Mr.
Yes.
Kaur placed
I am just confining myself to his
Which
submission.
page is that, Mr. It's from your copy.
Yes. From his copy, my lord, page
From your
5.
copy, which volume?
Volume 4. Line 7.
So it a page. Had given all
I
those.
think একটা ফাইল করে দিয়েছে বোধহয়।
দেখুন তো দিয়েছিল
লাস্ট একটা ম্যাপ থাকবে।
Which page, Mr. Kaur?
একটা বান্ডল থাকবে তাছাড়া 497
497 it starts.
Yes, 497 to 50.
Something 503 I think.
3 or 4. Yes.
My lord will be pleased to come to see, my lord, the award that has been given by him. Your lordship will please to come to page 503, the awarding portion. I'm not troubling your lordship with the first. He has, my lord, made a sort of legalistic argument with regard to the scope of the 2013 Act, and thereafter, your lordship will please to come to towards the bottom.
Yes.
As such, it is, my lord, about.
As such, the question of 40
Yes.
is 5 lakhs.
As such, total market value of the land in the present case will be rupees 24 crores 24 lakhs 26,244 per decimal into so and so decimal. All told, rupees 4 crores 52 lakhs 33,000, etc. According to section 26, 29 per schedule, etc. Your lordship, my lord, this he has just followed it. I've got nothing to say with regard to this. Kindly come to the last part of it. See, my lord.
Yes. Of that page.
On the next page.
Next page.
Page
Yes.
504.
Yes.
Just before the ordering portion.
Yes.
So this authority do not find any reason for allowing further interest as claim when the compensation is allowed in the light of the new Act of 2013. Now, my lord, this matter went before the appellate authority. The appellate authority passed the order. Your lordship wanted to have the copies of the appellate authority order in that perhaps maybe I can hand up to your lordship. My lord, what happened was this. This is 14th.
Appellate authority's order was also part of the records before the authorities.
No,
You are saying appellate authority's order in 14.
Yes. The appellate authority's order in 14 was not there, my lord, either in their brief or in our brief. So your lordship wanted a copy of the order of the appellate authority 33 and 14 separately. That has been prepared.
Mr. Mitra, I'm asking both of you.
Yes.
Whether I'm not saying that whether it is part of this writ petition. I'm asking you
Yes.
whether those were part of the records of competent authority as well as the appellate authority.
Yeah, my lord, 33. My lord, in the appellate authority's impugned order, both my lord, appellate authorities order of 14 and 33 have been compared.
Appellate authority's order was
Yes,
considered.
appellate authority. My lord, I tell you, lordship, what had happened.
Mr. Court, please check up this.
Yes.
Because
Appellate authority's order was not, my lord. What happened was this, my lord. In the competent authority did not rely upon the appellate authority's order in 33. So, my lord, that criticism was made that we relied upon 14 for the purpose of giving the award, but 33 is more akin to, this is, my lord, more more of an exemplar. So far that's concerned, why have you not considered that? And detailed, I have given your lordship paragraph 11. 11.1 to my lord, thereafter, there are 11 paragraphs, sub-paragraphs of paragraph 11. And there, my lord, he has detailed in discussion with regard to 14 and 33. That you have relied upon one, you have not relied upon which is more appropriate in the facts of this particular case. So, my lord, I am emboldened to, my lord, place it before your lordship.
where is the appellate authority's order?
Yes, my lord, I am giving your lordship.
The court, please check up whether these were.
14 is not considered anywhere. The appellate authority has only considered the order of the appellate authority of 33.
Well, let me check up. Let me check up.
Please check up. I don't think on facts there will be. Mr. Mitro is saying that that was considered. Please
Your
check up.
lordship, kindly give me 1 second.
Mr. Mitro, Mr. Court, can I take 1 minute?
Yes.
Yes.
Yes, Mr. Trivedi.
I have heard, Miller, what the basically the factual matter. Yes, Miller, there is license had been.
In 2 minutes.
All right.
Miller, I'm here.
Only one thing. Can you appear in that matter for the state?
My lord, if my lord appoints me as an amicus curiae, I can, my lord, because there is no panel in existence, my lord, then I can do it, my lord. There is no issue.
So please do that because they are saying Mr. Sureka has filed one writ petition. Mr. Banerjee also the private respondent in this is Shuddha Sattva Banerjee. Shuddha Banerjee has
Please
filed this
help me.
petition.
Try
Shuddha
and
Sattva
find
Banerjee
out
appealing for the
if
private
both have
respondent.
14 and 33 discussed
He will also
in
file a writ petition in course of day. Yes, sir. So if you can appear in that matter,
My lord,
both these
my lord,
matters,
if it is my lord's pleasure, my lord will record an order after my lord finishes up this with this matter. I'll be there and my lord will record an order and ask them to serve copy on me so that my lord I can take instructions because appropriate instructions so that I don't cut off.
Milord, I'll also be. I'm sorry, Milord. I'll also be filing my writ petition in course of the day.
Mr. Banerjee, please junior to serve a copy upon Mr. Trivedi in
100%. Milord. Your lordship is keeping it day after
Mr.
or
Trivedi
on Monday, Milord.
day after tomorrow.
Day after tomorrow, my lord.
To also take some.
My lord, I'll supply the name of my junior and in whose name they can serve, my lord, though he is not in the state panel, but my lord, he is because as a senior I cannot take notice. So my lord, I will supply
Day after is Friday. Instead of Friday, can it be Monday, my lord?
Your lordship, there is an urgency. Your lordship, Mr. Banerjee is coming. Kindly pass it over for 2 minutes.
No, there is no.
He has urgency.
Your lordship, it's
I also have urgency.
Well, has been filed.
Very well. I'll file it and serve it
Monday.
upon Mr. Trivedi and on the other side, lordship. keeps it day
Monday
after
would
tomorrow,
have been
my
the
lord.
best, my lord. My lord, I'm maybe it is urgency, my lord. I'm going to because my lord, today I'll get the petition. Which manages petition.
That's possible. Otherwise, let me.
My lord, no issues, my lord. My lord,
what? Keeping it on Friday.
My lord, my lord's word is my command, my lord. Will keep it on Friday. I will not cut a sorry figure, but if I get 2 more days, my lord understands my precarious situation.
I'm saying it's urgent because
Well,
I'm also not.
My lord, the urgency that he seeks is to actually throw me out. With a 2 days notice, he's cancelled my UD license of Bancharam, which was there for 5 years.
Consider that. Please give copies to Mr. Trivedi and please supply
My
me
lord,
the name of a junior.
I shall here and now to both of
So I
them.
can appoint you as the advocate for the state also.
My lord, as of now, my lord, what the honorable coordinate benches are doing, they are appointing us as amicus curiae, my lord. And my lord, as far as I'm concerned, my lord, I represent the state, but pro bono I'll do it because then the entire protocol. Yes, my lord. So my lord will appoint me an amicus curiae, then I am well within my rights. not being formally appointed, but appointed by my lord, I can take all instruction, I can assist. My lord.
All right.
I'm grateful.
Very grateful.
The name of your
Yes, my lord, I will.
Yes.
Yes,
Yes, sorry, Mr. Mitso.
my lord, will kindly not embarrass you.
Very grateful.
Yes. Yes, Mr. Mitso.
Yes, are very helpful to me. They always come forward, my lord, whenever I need their assistance, help. My lord, kindly come to page 349.
349.
349, the
Of
order
that bunch.
yes, but no, volume 3 of the appellate authority order, impugned order,
See,
the order which is being, lordship can.
volume C.
11, paragraph 11.8.
Yes, volume C of your matter.
Yes, of my matter.
Page.
Page 349.
Yes. Yes.
Paragraph 11.8. May I place it? I had placed it already, but I am placing it again. The learned competent authority failed to observe as to why the claimants are in so haste in purchasing so huge plots after publication of notification under Section 21 of 1978 Act. They were why so fast in applying for mutation, and even before mutation, entering into development agreement. That too with a novice company, and then applying for conversion. The malafide intention of the claimant to squeeze public money is manifested from their acts. But unfortunately, the learned competent authority ignored all these. The claimants waited till conversion and filed the claim case only after the land was converted into housing complex. It's very pertinent to note here that NGA 33 of 2014, the competent authority rejected the claim of the commercial land on the ground that conversion was done after vesting. But in the present case, NGA 92, the same authority allowed the claim of commercial nature, though in this case too, the conversion was done after vesting. In both cases, there was development agreement for housing project. In both cases, the valuer's report and chartered accountant reports were filed to establish the claim. It is beyond my understanding as to what prompted the learned authority, competent authority, to take note of NGA 14, in which the claimant had been compensated at the rate of rupees so and so per decimal. Learned competent authority failed to note that the case land of NGA 14 was purchased by the claimant in the year 1993, much before, that's 20 years before, the notification of acquisition, and already converted the commercial land before 2 years before acquisition. And the geographical position of the land is much more prominent from commercial point of view compared to the case land of the present case in 92. The observation of the competent authority, the claimant spent crores in the process of conversion, attracts doubts. Is it really required to pay so much of amount for conversion? The claimant did it on his own peril, and they knew that the land is vested to the government and they are no longer the owner of the case land, and they have no right or authority to apply for conversion in spite of the fact that they did it for so and so. So, my lord, after my lord, I placed this, your lordship was pleased to observe. Then do you have the appellate authority's order in 14 and 33? Because there is a comparison. And in this, my lord, impugned order, this has been done. So, my lord, I respectfully submit to your lordship that it.
Copy of the
Yes, of course. Only copy of the order 14 or দুটোই দাও Lordship will can give me. তোমাদের নেই 14 আর 33 কোথায় আছে 33 well insofar as 33 appellate authority is concerned that is at page 268 of our brief and when 14 is concerned the 14 copy I can give to your lordship
14 has not been annexed here.
no 14 appellate authorities order has not been annexed.
This was not part of the records, the appellate authorities.
It was not part of the.
This and the Supreme Court order, both were not part of the.
No, my lord, I am on this, my lord. Let me proceed in my own way. My lord, I am proceeding on this basis. I have shown to your lordship, my learned friend had said that one should follow the competent authority's order in 14 because it has been approved by the Supreme Court. I say the Supreme Court did not approve of the competent authority's order. It approved of the appellate authority's order. The order which has been passed by the appellate authority. And I tell you, lordship, my lord.
Was it modified?
Yes, it was. Because what happened, I tell you,
Stage.
yes, I tell you, the appellate authority slightly modified the order of the competent authority. How? I'm telling you, lordship. So far as the compensation is concerned, that had been upheld. But my lord, the competent authority did not allow the interest at 12%. In spite of the fact that he had been so voluble in his narration of the provisions of law, section 25, 26, 27, one has to follow, this is this land losers, therefore you do this, you do that. But my lord, at the time of giving interest, my lord, he did not do so. So the appellate authority said, no, there is some mistake in there. You did not give the interest at 12% per annum. I'm adding interest. So 9 crores and odd was the award given by them, by the competent authority. The appellate authority increased it to 14 crores by allowing the interest at 12% per annum. And that had been, my lord, confirmed by the Supreme Court. So I submit to your lordship that what has been confirmed is the appellate authority order, not, my lord, the trial. That is the first submission I want to make before lordship. And my lord,
that goes against you.
I say whether it goes against me or not is not the point. Point is, what is it that has been confirmed? And I'm giving your lordship the kindly see, my lord, the appellate authority has compared 14 and 33 in its judgment, in its order. So I am my lord, taking exception that it is not been considered. It has been considered. The two situations, my lord, there are two plots at your nearby to the, my lord, the impugned plot. So, my lord, the appellate authority had before it the records of 14 and 33. He found that so far as 33 is concerned, that is more akin to as an exemplar, that is the one that should be taken note of. Why? Because, my lord, in that case also, the conversion took place after acquisition. So, my lord, this purported conversion is a void conversion. It could not have been converted in terms of section 4C of the Land Reforms Act. So, my lord, after taking note of that, he said that this is in perimeteria with 92. Why? Because in 92 also, when, my lord, section 21 notice was given, soon thereafter, they knew exactly that this alignment of the metro is going to pass that way. In fact, my lord, the deed records
this portion has been,
yes, that the metro alignment is there. And also it was also a thing that has to be taken note of, that at the time when the metro had been considering for acquisition of the property, it was not acquired. They entered into an agreement for sale. Not only they didn't stop there, they entered into a development agreement, knowing fully well that there is a metro alignment with that kind of knife-shaped property in respect of that. They didn't stop there. They immediately applied for mutation. They immediately applied for conversion. The conversion was not allowed. Conversion was allowed only after the property has been acquired by the metro railway. Therefore, my lord, if one has to take an exemplar, one has to consider the appellate authority has considered by way of an exemplar 33 and 14. And my lord, he has chosen 33 because 14 is, my lord, the acquisition had taken place long after, my lord, purchasing the property. Long before, my lord, the acquisition conversion has also taken place. Already, my lord, the person concerned had come forward with, my lord, so to say, a sort of plan for development of the property.
Again, Lord, argument on this.
So, Mitsu, you have argued these points.
No, I am
This
Only the judgments and other things. This you have argued. The appellate authority's order of 14. What you want to show anything?
yes, I
Only that interest
I wanted
part.
to show, no, I wanted to show to your lordship, my lord, the one that has been placed before lordship is page the order of the competent authority. I wanted to
Yes, their
to-
interest was rejected or
Yes.
not allowed. in
and
that.
but that was allowed by the appellate
Show
authority.
me that portion.
Yes, my lord, your lordship will kindly take that.
This is appeal number. What is the appeal number?
It is NGA. It is
14 is
by
by 2 orders.
It is appeal number 2 of 2019.
You have given,
In case number NGA 14. I have just now handed up.
there are 2 judgments. One is of claim appeal number 6 of 2018. Another is of misappeal number 2 of 2019. Why?
The one that I have handed up is,
Is remand.
dated 5th March.
5th March and 25th of June. No, I think it was remanded.
My lord, I don't know. I have given the key. কোনটা কি দিয়েছো আমি জানি না, এইটাই তো।
Because 2 judgments have been handed over. One is dated 5th of March 2019.
This is the 5th March.
And another is 25th of June 2018.
Which is the appeal? Lordship, kindly give me 1 second.
Oh, I think there was a remand by the High Court against that. After remand, I think this is the final judgment.
Lord, Order 41, Rule 27. Applications were filed by the appellate authority after preferring the appeal. What the
14.
in 14 in not in sorry.
I think there is some remand. Mr. Mitchell, do you have an extra copy so that Mr. Court can also verify?
But in
that?
fact, I don't have the copy that your lordship has. So, my lord, I am, my lord, searching for
Mr.
that.
Court, please check it up. I think the 5th of March.
I was talking about our matter. I didn't know about it.
14. I think the 2019 order must be the. You take to the last page of 2019 order. Yes, pursuant to the order passed by the High Court on remand. Please see the last page of 5th of March 2019.
5th of March, yes, last.
Last page top.
That the
The
instant
second-
miscase of so-and-so is allowed on contest as per direction of the Honorable High Court, Calcutta, passed
First
by.
2 paragraph, Lord, clarifies this.
The
The first 2
claimant
paragraph of the 2019 order.
So that
Ekটু
would be
দেখে
the
নিন।
final order.
This must be the final order.
So 2018 may not be necessary. Otherwise, it will be
Yes.
confusing again.
Yes.
বাদ দিয়ে দিন।
So Mitchell, please take it 2018.
But then your lordship is keeping.
Or can I get that?
I'll just, Lord, have a quick look.
March.
I
Yes,
don't
yes.
have a copy of this.
All right, please. Yes, Mr. Mitchell, you can place that from your copy.
I'll just
Your
give
lordship has got 5th March.
Or you go through that.
Your lordship has
here.
got 5th March order.
No, I've given it to Mr. Kaur. You can place it
I-
from
I-
there.
একটা কপি দেবেন স্যার।
So he is having only 2 copies.
I see. না না আপনার আছে? আচ্ছা।
That's how we can do it.
Yes.
Your lordship will please to
Page 6.
page 6. Kindly come to
Middle
me.
paragraph. As
Yes.
per the direction.
As per
of
the
High
district,
Court.
days, Honorable High Court at Calcutta passed in so and so, OPL will get an additional amount of compensation at interest at 12% per annum on the market value of the case land for the period on and from 25th March 2013 till the date of judgment passed by the authority, that is on 25th June 2018, to the tune of rupees 2 crores 84 lakhs. As per direction of the Honorable High Court, Calcutta passed in so and so, dated so and so, the appellant claimant will get solatium equivalent to 100%, and that was added. And then, my lord,
12% interest on additional compensation.
yes. So, my lord, ultimately the amount was 11 crores 89 lakhs. And this, my lord, was not allowed originally, my lord, by the competent authority. If your lordship, my lord, kindly comes back to page, yes.
This was a firm.
Yeah, it was a firm. This was a
So
firm.
you see, that is what Mr. Mitchell is saying. It's the appellate authority.
This is the
Order which has been affirmed
12% interest has been allowed.
which
this-
is refused by the
competent authority at
That has
page
been allowed.
504.
Yes. Oh, this is the order.
Supreme
This is
Court.
a Supreme Court order.
Supreme Court affirms the High Court.
Supreme Court affirms one of the appellate authority's order.
All right. Anything more, Mr.
Yes, here only another thing I just wanted to show to your lordship. My lord, kindly take, it's very, very interesting. Your lordship kindly comes to page 499 of the competent authority order, which was placed before your lordship yesterday. Kindly come to page 499.
Yes. 499.
Okay,
Yes.
kindly see, my lord, there is a box
Yes.
in the middle. On the other hand, OP Metro Railway examined none and produced some documents which have been marked exhibit. And now kindly come to item 4. DM's 24 Parganas letter dated 29 September. Your lordship sees that. This is that at page 278. That particular thing did not contain. If your lordship may kindly, just for a second, kindly go back to that page 278. I'm going to go to the volume 2.
That did not contain Vastu commercial.
Bus commercial. So, my lord, what happened in this case, so far as the claimant is concerned, claimant is saying that look, you have given a chart which contains all sorts of things. Give me that chart. Which chart? Kindly see what it contains. It contains, my lord, classification of land, Sali, Bastu, Bin, Hal, and Doba.
Yes, Vastu commercial was
Not there. So, my lord, the claimant referred it back. He said that, look, I have converted it into Bastu commercial. So, it is not there. He objected to, my lord, DMs. So, my lord, the matter was referred back to the Inspector General of Revenue. And he gave, my lord, a chart. I give your lordship that.
Where is this letter, Mr. Mitso? This letter of 27th of April 2017, Exhibit G in that matter.
Yes.
Where is that?
Exhibit G. That is the letter. Now, I'm going to go to the unnecessarily exhibit set.
You have an additional copy? Can you give it to Mr. Paul?
Exhibit G. Yes. Lordship will kindly see Exhibit G.
27th of
ওটা বার করে দাও না
2017.
exhibit
কপি দেবেন
হ্যাঁ দেবো copy আছে kindly see my lord Exhibit G. Government of West Bengal, Directorate of Registration and Stamp Revenue, signed by Deputy Inspector General of Registration, in reference to so and so, dated so and so, the undersigned is directed to send herewith report obtained from ADSR and ERAC in respect of
classifications, Vastu and commercial.
Vastu commercial. And that was given, and that particular rate was allowed to this the claimant in 14. The reason why I'm saying it to your lordship is this, that the person who is, my lord, has a grievance with regard to the rates given by, my lord, the collector. He raises objection, and that objection is immediately, my lord, taken note of, and rectification order is passed. And, my lord, what was, my lord, lacking in
Not a rectification.
no, not rectification, giving
Because,
something.
Those did not
Contain.
The DM's report did not contain these two classifications.
So this
Inspector
classification is
General
given.
did this.
Therefore, what I am submitting to your lordship is this, that a claimant who is aggrieved by, my lord, the collector's order for whatever is the reason, it is not that he doesn't have any, he does not go out into the wide field and starts looking for, my lord, some my lord engineer or some surveyor or for the purpose of getting a valuation. The authorities are there. My lord, any grievance in respect of that can be ameliorated by, my lord, looking into that. This has not been done. Why I am saying so, my lord, again, I go back to, my lord, that one cannot ignore the provisions of law. My learned friend says that after 2013, this Metro Act, these provisions of Section 11, Section 13, 1, 2, 3, 4, these have become totally obsolete. This was the argument.
13.4.
13.4 has become obsolete. Kindly, my lord, see up to 13.4. In terms of 13.4, this has been done. What happens is this, my lord, as I told your lordship yesterday, I don't know whether I have been able to make myself clear or not. I said that under the law, this is a simple point that I argued. I said that under the law, as it exists, Section 13.1 comes into the picture. In terms of that, where any land, building, street, or passage is acquired under the Act, there shall be paid a compensation. Who is
That has to be computed according to 4.
Yes, and this 4, by reason of, my lord, the new Act of 2013, has undergone slight change. So further things had to be taken note. Section 4, Section 13, subsection 4 contains certain parameters. Now, my lord, certain additional parameters have been added. And, my lord, they are contained either in Section 28 as parameters or in the schedule. So, my lord, I mean, I feel, my lord, that there is no change in the law in the sense that a particular provision has been rendered nugatory. No, I think that's a wrong reading of the section. This particular section 13.4 has been supplemented by, my lord, 2013 Act, Section 26, read with Section 28, read with Schedule 1. And if read together, then, my lord, there is no problem. Do not render a particular provision nugatory by reason of the fact that this has happened. And now, my lord, lastly, if I may respectfully submit, this is my respectful submission. I did not go into any complication in this. My lord, lastly, my lord, the judgment of, my lord, the Supreme Court, which has been given, which has been relied upon, of Chief Justice Gavai's judgment, my lord, in 2025 SCC. I shall take very quickly, I shall tell you, show your lordship. My lord, here.
Can I come back after 5 minutes?
Yes, my lord. Your lordship, I shall take 5 minutes. I shall take 5 minutes. If your lordship, my lord, wants to come back, my lord, I shall wait.
Yes, I will come back after 5 minutes.
Yes, my lord. Justice কোন যাচ্ছিলেন তিনি ওখানে ঘুরবেন আমাদের প্রথমে দাওয়াত ছিলেন তিনি লেকচার দিতেন ঘুরে ঘুরে
Mr. Mitra was telling us a very interesting story. Your Lordship Lord, just went out for 5 minutes for a walk. So he has a very interesting story to tell your Lordship. I request him to kindly
no
narrate the same story.
I heard it. I have not seen one English judge. I think Mr. Anindya Mitra will be able to remind me who it was, or Mr. Pradeep Ghosh will be able to tell me. He used to walk around on the dais. So instead of the learned judge having, my lord, pain in the waist, it's the counsel who used to have pain in the neck.
Yes.
all the time oscillating, my lord, their neck like this. This is what I have heard that from. He had some problems, so he could not sit there. So he used to walk on the podium.
Nowadays, the doctors are advising, because if you sit for a long time, they are saying that please change the posture after some time, then again.
Maybe that was the reason why, my lord, our if I may say so, our ex-chief minister used to walk on the
podium with ভাষণ দিতে দিতে হেঁটে হেঁটে বেড়াতো।
This is what he used to do. But I don't request your lordship to follow that. Well, kindly come back to
This 2025 SCC online,
yes
1519.
কোথায় গেল আমাদের? Lordship will kindly say very quickly. I am not going to trouble your lordship with very much. Kindly come to paragraph 4. This particular judgment is concerned with the interpretation of, my lord, a particular act, which is, my lord, the Maharashtra Industrial Development Act mentioned in paragraph 4.2. And there, that is, my lord, 1961 Act. And, my lord, kindly see paragraph 4.5. Being aggrieved by the quantum of compensation awarded, the appellant accepted the compensation under protest and simultaneously filed a reference under section 18 of the Land Acquisition Act of 1894. So, my lord, it is under
Maybe those provisions were borrowed for the purpose of
compensation
and reference.
determination of compensation. Therefore, my lord, this was also concerning, my lord, the 1894 Act. In fact, my lord, the 1894 Act did not have the mechanism for or the parameters laid down as, my lord, is contained in the 2013 Act. So, my lord, today, when 2013 Act is there holding the field, well, I don't think your lordship need not go into anywhere else, because all these, the parameters have been set out in the section itself and in the schedule. So, my lord, one can follow straight away without any fear of any my lord, there being any error ultimately out. My lord, therefore, I respectfully submit to your lordship, kindly, my lord, keeping that in mind when your lordship looks into this particular judgment, kindly come to paragraph 22. In the context of that particular act, this paragraph 22 has been written.
Yes.
It can therefore be seen that the highest exemplar sale deed dated 31st March 1990, showing market value of rupees so per acre, available at serial number 4 and relied upon by the claimant as a bona fide sale instance.
Overlooked by the reference.
Yes, was completely overlooked by the reference court. It would, however, have been different matter if the reference court, for the reason to be recorded by it, came to a finding that the sale instance at serial number 4 was not a bona fide one or a sham bogus one, and which could not be relied on. Now, my lord, just keeping in mind this, your lordship now kindly come back to this section 26 of the 2013 Act. Well, the section itself says so. Now, my lord, I don't think your lordship will have to go anywhere else. Kindly come to section 26, subsection B, 1B. The collector shall adopt the following criteria in assessing and determining the market value of the land. So, market value, how it is to be assessed, my lord, it has been laid down here. Then B, the average sale price for similar type of land situate in the nearest village or nearest vicinity area. This is exactly 14 and 33 in our case. So, my lord, the appellate authority compared 14 and 33 nearest vicinity area and chose 33 instead of 14. Because, my lord, 33 had more akin to, my lord, the subject land which is there. Lastly, my lord, if I may just wind up my submission on this, well, I would request your lordship not to ignore a single word in what is contained in this section. Section 26 again come.
26.
Yes. The average sale price, etc., situate nearest, then kindly come to this, whichever is higher,
Yes.
and then the next proviso, kindly say, provided that the date for determination of market value shall be the date on which the notification has been issued under section 11. Therefore, my lord, one cannot, my lord, take note of the fact that subsequently an agreement was entered into for the purpose of development of the land. It is my lord,
That is prior.
my lord, I submit to your lordship that one has to look into it is, my lord, kindly see this the facts of our case. A land which has already been acquired is sought to be converted, and on the basis of that conversion, you enter into some kind of an agreement for the purpose of development.
But there shouldn't be a re-argument on this.
No, I can understand, my lord. It's a rather uncomfortable argument. And my learned friend is
For whom?
just
That's the
for,
point. For whom?
for my learned friend is justified in stopping me. I am stopping here, my lord. Just I am reminding your lordship the date, the situation, the location, and the date both are to be taken into account.
And potentiality. That also has to be taken into consideration. My learned friend is stopping at that without taking the point of
want to file any short note.
is it necessary? I think my lord has
I've
taken.
taken notes. I've considered if, both of you.
But if your lordship wants, my lord, I can give a short note of submission, very short note.
I think, Lord, your lordship has taken, Lord, extensive notes. I wouldn't burden your lordship with a note, because part of the burden will come back to me. That is the reason I'm trying to avoid that.
you want, you can, because
Very
after all,
ठीक है.
but make a short note, don't make it. And Mr. Mitra has not relied upon any judgment.
No.
So
I am relying upon those judgments.
You need not attach those decisions. You can only refer to on one points and other things. When can you file, Mr. Banerjee? You will be preparing.
এটা তোমার department.
Plus do it before the vacation.
Correct.
Next Wednesday.
Next Wednesday.
Mr. If only those points which you want to rely upon. Yes. Banerjee,
Item number 6. Mr. Yes.
requested him to appear in this matter.
Yes. Kindly take it up tomorrow. I'll tell you, Lordship, why X lies.
Said because Mr.
Achha,
Jindal also, because Mr. Banerjee will be filed, Mr. Other Banerjee.
Other Banerjee. He will be filing.
He's Bandyopadhyay or Banerjee?
No, he's Banerjee, my lord. He's
also
Banerjee.
So other Banerjee, so he will be filing in course of this day. The Trivedi
Might read sometime.
has to take instructions. He requested for Monday. I requested him to come on Friday.
Friday.
Item number 6 at a So Banerjee, can you request him to give the presentation date of his matter on Friday? Of his matter.
For which perhaps he might need leave. Otherwise, appellate side two clear dates.
That is why otherwise cannot be taken up on Friday.
So what I'll do is, I'll request his juniors to appropriately arrange. Otherwise, they'll formally seek your lordship's leave with at that 2 p.m.
Please ask them to
I'll
put the
coordinate
date
with
of Friday. Otherwise
Otherwise, it will not.
cannot be taken up. Yes, call the next matter. Yes. That jurisdiction point.
Last occasion I had appointed my case.
Yes, only on the point of jurisdiction.
What my learned friend, my lord, is the objection of
Use the microphone.
lack of territorial jurisdiction. My lord, on this point, my lord, I will make my submission. Now, your lordship can remember that initially, my lord, when the writ petition was moved before this honorable court, the writ petition was heard on merit and the same was dismissed summarily. My lord, at that time, my lord, my learned friend, my
Did
lord,
not take
any objection, and he accepted the my lord, judgment and order of the learned writ court
You preferred an appeal.
without any. Now, question is this, my lord. I prefer an appeal. My lord, this
Appeal was also
my lord,
allowed in your
I am
favor.
coming. This appeal should be preferred by my learned friend. But my learned friend did not prefer an appeal. Because when any matter was passed by the writ court, and if it is an incorrect or illegal order, because in lack of territorial jurisdiction, it is
But it is order is in his favor. How he cannot prefer an appeal?
lordship favor on merit, not in territorial jurisdiction.
On merits. If it is rejected, he cannot be said to an active party. He
But-
cannot prefer an appeal.
But that order of the writ court, my lord, is not legal, or my lord, it is not a
Two things. One is there is a distinction between an appeal and a cross objection. You may say that he ought to have filed a cross objection, but not an appeal. Appeal is if the ultimate decision is against a party, an aggrieved party can prefer an appeal. Now, if an appeal is preferred, suppose you have preferred an appeal, and he says he raises an objection because the jurisdiction has been decided against him, he could have preferred a cross objection. That's a different thing altogether. But when the ultimate decision, final decision on merits is in his favor, he cannot prefer an appeal. Cannot prefer an appeal.
now very well.
Appeal is by a person aggrieved. He cannot be said that's the ultimate decision. That's one. Second is even I take everything that he has not challenged the jurisdiction, territorial jurisdiction up to the appellate stage. I accept. I take it one step further. He consented to that. My question to you is whether consent can confer jurisdiction upon the court. Let us take an example, hypothetical case. All cause of action appeared outside the territory or within this in Delhi. Both of you agree, consent, come here and matter is decided. Whether this court will get jurisdiction, even both of you give consent.
Lordship consider, my lord.
That is my query to you. Please show me that consent can confer jurisdiction.
On the last occasion, your lordship, that.
Where is the decision?
Yes, yes.
You have not brought
Lordship,
those decisions.
My lord, I have come with the decision.
Starting from Privy Council, those decisions are there. That consent can confer jurisdiction. Show me.
এটা একটা দিয়ে দিন তো। Report it. My lord, it is 2019, volume 3 SCC, page 594. Lordship, straightway come to paragraph 12. Section 21 of the CPC. Paragraph 12.
Yes.
Section 21, objection to jurisdiction. No objection as to the place of suing shall be allowed by any appellate or revisional court unless such objection was taken in the court of first instance at the earliest possible opportunity, and in all cases where issues are settled at or before such settlement, and unless there has been a consequent failure of justice. Second, no objection as to the competence of a court with reference to the pecuniary limits of its jurisdiction shall be allowed by any appellate or revisional court unless such objection was taken in the court of first instance at the earliest possible opportunity, and in all cases where issues are settled at or before such settlement, and unless there has been a consequent failure of justice. 3. No objection as to the competence of the executing court with reference to the local limits of its jurisdiction shall be allowed by any appellate or revisional court unless such objection was taken in the executing court at the earliest possible opportunity, and unless there has been a consequences failure of justice. Next, my lord, paragraph 13. Subsection 1 of section 21 provides that before raising an objection to territorial jurisdiction before an appellate or divisional court, two condition precedent must be fulfilled. The objection must be taken in the court of first instance at the earliest possible opportunity, and there has been a consequent failure of justice. The provision which the legislature has designedly adopted would make it abundantly clear that an objection to the want of territorial jurisdiction does not travel the route or to the inherent lack of jurisdiction of a civil court to entertain the suit. Hence, it has to be raised before the court of first instance at the earliest opportunity, and in all cases where issues are settled on or before such settlement. Moreover, it is only where there is a consequent failure of justice that an objection as to the place of suit can be entertained. Both these conditions have to be satisfied. Next, paragraph 14. The learned counsel appearing on behalf of the respondent has submitted that the objection up to the lack of territorial jurisdiction was raised in the written statement before the trial court, but evidently the suit was dismissed expertly after the respondent failed to participate in the proceeding. The provision of section 21(1) contain a clear legislative mandate that an objection of this nature has to be raised at the earliest possible opportunity before issues are settled. Moreover, no such objection can be allowed to be raised even by an appellate or divisional jurisdiction unless both sets of conditions are fulfilled. Then your lordship kindly come to paragraph, my lord. Next page, my lord. Third paragraph. Next page, third paragraph. With reference to objection. Third paragraph. My lord, started from with reference to objection relating to territorial jurisdiction. Section 21 of the Civil Procedure Code enacts that no objection to the place of suit should be allowed by an appellate or divisional court unless there has a consequential failure of justice. It is the same principle that has been adopted in section 11 of the Suits Valuation Act with reference to pecuniary jurisdiction. The policy underlying section 21 and 99 of the Civil Procedure Code and section 11 of the Suits Valuation Act is the same, namely that when a case had been tried by a court on the merits and judgment rendered, it should not be liable to be reversed purely on technical grounds. The word technical grounds, unless it had resulted in failure of justice, and the policy of the legislature has been to treat objection to the jurisdiction, both territorial and pecuniary, as technical and not open to consider. My lord, my submission before your lordship, that my lord, I am a constable. My lord, a valuable part of my life has been spoiled. As had there been any, my lord, point was raised before the trial court or the appeal court, my lord, this part of my life should not be spoiled. But due to such, my lord, negligence on the part of the respondent authorities, my lord, I suffered. And the point of territorial jurisdiction is a technical and not open to considerable by an appellate court unless there has been a prejudice on the merit. What prejudice, my lord? They have contested the case on merit. The lordship colleague consider the matter on the merits. What prejudice has been caused? Only for the technical point of territorial jurisdiction. Then your lordship can come again, my lord, paragraph 19. In Hiralal Patni versus Palina, a person filed a suit on the grounds original side of High Court of Judicature at Bombay for recovering commission due to him. The matter was referred to arbitration and it resulted in an award in favor of the plaintiff. A degree was passed in terms of the award and was eventually incorporated. In a degree of the High Court, in execution proceedings, the judgment debtor resisted it on the ground that no part of the cause of action had arisen in Bombay, and therefore the High Court had no jurisdiction to try the cause, and that all proceedings following thereon were wholly without jurisdiction, and thus a nullity. Rejecting this contention, a 4 judges bench of this court held the objection to its Bombay High Court territorial jurisdiction is one which does not go to the competence of the court and can therefore be waived. In the instant case when the plaintiff obtained the leave of the Bombay High Court on the original site under clause 12 of the labor patent and correctness of the procedure or of the order granting leave could be questioned by the defendant or the objection could be waived. When he agreed to refer the matter to arbitration, though a court, he would be deemed to have waived his objection to the territorial jurisdiction of the raised by him in his testimony. It is well settled that the objection as to a local jurisdiction of a court does not stand on the same footing as an objection to the competence of a court to try a case. Competence of court to try a case goes to the very root of the jurisdiction, and where it is lacking, it is a case of inherent lack of jurisdiction. On the other hand, an objection as to the local jurisdiction of a court can be waived, and this principle has been given a statutory recognition by enactment like section 21 of the Code of Civil Procedure. Then, my lord, paragraph 20. In Horistimal Lal Modi versus DLF Universal League, this court held that an objection to territorial and pecuniary jurisdiction has to be taken at the earliest possible opportunity. If it is not raised at the earliest, it cannot be allowed to be taken at the subsequent stage. This court held thus the jurisdiction of a court may be classified into several categories. The important categories are territorial or local jurisdiction, pecuniary jurisdiction, and jurisdiction over the subject matter. So far as territorial and pecuniary jurisdiction are concerned, objection to such jurisdiction has to be taken at the earliest possible opportunity. And in any case, at or before settlement of issue, the law is well settled on the point that if such objection is not taken at the earliest, it cannot be allowed to be taken at a subsequent stage. Jurisdiction as to subject matter, however, is totally distinct, stand on a different footing, where a court has no jurisdiction over the subject matter by reason of any limitation imposed by statute, charter or commissioner cannot take up. An order passed by the court having no jurisdiction is then your lordship can come to paragraph 23. The objection which was raised in execution in the present case did not relate to the subject matter of the suit. It was an objection to territorial jurisdiction, which does not travel to the root or to the inherent lack of jurisdiction of a civil court to entertain the suit. An executing court cannot go behind the degree and must execute the degree as it stands. In Vasudev, Dhanjini and Modi versus Rajabhai Abdul Rahman, the petitioner filed a suit in the Court of Small Cause, Ahmedabad, for rejecting the defendant's tenor. The suit was eventually agreed in his favor by this court. During execution proceedings, the defendant raised an objection that the Court of Small Causes had no jurisdiction to entertain the suit and the degree was denied. The court executing the degree and the Court of Small Causes rejected the contention. High Court reversed the order of the Court of Small Causes, dismissed the petition for execution. On appeal to this court, a 3 judges bench of this court reversed the judgment of the High Court and held thus: a court executing a degree cannot go behind the degree between the parties.
Yes, that is well settled. Court executing court cannot go behind the degree. So you are on this principle that the objection as to the territorial jurisdiction has to be taken at the first instance for the appellate or the revision
and
court.
on mere technical point of territorial jurisdiction, my lord, the order of the my lord, the my lord, the court cannot, my lord, it is a technical point, my lord, because on merit, my lord, if it is gone to the,
Article 226.
my lord, I know that 226, 1 and 2.
Yes. So whether it is a question of jurisdiction as to the subject matter or not.
My lord, that point of jurisdiction,
The Honorable Supreme Court has made a distinction between the jurisdiction as to the subject matter and the territorial jurisdiction. If there is no jurisdiction as to the subject matter, it's nullity. Paragraph 21 and 22. We may, however, hasten to add that a distinction must be made between a decree passed by a court which has no territorial or pecuniary jurisdiction in the light of section 21 and a decree passed by a court having no jurisdiction with regard to the subject matter of the suit. So here is the disciplinary proceedings is the subject matter. So if entire proceedings happened outside the territories of the state of West Bengal, no part of the cause of action, is it not barred under Article 226(1)?
but section 21 of the CPC, my lord.
The distinction between the subject matter, it's a subject matter, not only with regard to the territories. It says you cannot issue a writ. And in this matter, it was a partition suit. There were two properties involved. One was of Ranchi, another of Varanasi. The law is in one of the courts you can file. That's the case in Ranchi, it was filed. It was not a case of lack of jurisdiction.
But when the appeal was heard, when the appeal, they did not raise any objection.
This is the distinction. Subject matter, it's a nullity. Yes,
But
what do you say?
and
What do you
Lordship-
say to this judgment?
Yes, Lordship, that the judgment is, Lordship, referring to the Lordship first instance. So here, this court is the first instance. Lordship,
Not the
kindly
first
appreciate.
instance.
Lordship may
It's
kindly,
able to appeal
Lordship may
thereafter
kindly,
remand.
kindly appreciate.
Cannot say it's a first instance.
Lordship may kindly appreciate. First, that it was filed. It was dismissed on the first date, Lordship, without exchanging any pleadings or given an opportunity to file the opposition.
What prevented you from taking that point in the appeal?
Lordship, may I submit? And in the appeal also, Lordship, the appeal court has not gone into the merit of the Lordship. May kindly takes the appeal court's
Question
order.
of jurisdiction.
Lordship,
You have not raised
it
that.
has been, Lordship, it has been categorically observed that, Lordship, that it has been remanded back to the before this honorable court to, Lordship, decide the matter fresh. So, Lordship, kindly appreciate in my respectful submission, Lordship, this for as if the matter has been.
Want to cite?
Lordship,
Your learned friend has cited this decision.
Lordship.
You have
I'm
any
not,
clear
Lordship,
decision?
because that this is well settled, Lordship, that the court is deciding.
Cited a decision. Territorial jurisdiction.
But here, Lordship, it is that on the first kindly, and this judgment is no otherwise not relevant to this present circumstances, Lordship. Kindly appreciate
You
that.
cite a decision which is relevant to your
Lordship, that I need to come back, Lordship, that on that.
So for this was adjourned.
On the your Lordship that. And he was to satisfy that, but this is
not to satisfy.
But otherwise, this judgment is also not relevant. Here, the suit was filed.
Dissatisfied.
No, Lordship. Here in this.
Yes, satisfied. You have dissatisfied.
But otherwise, Lordship, I must submit that, Lordship, that this judgment is not relevant to the Lordship present situation also.
Why?
Because this in the
territorial jurisdiction section 21, it says
it was
at
not
the initial stage. So it's after remand.
This is the Lordship. This is the first instance, Lordship. In that, Lordship may kindly appreciate that. The appeal court remanded back to this court to
When
decide
can you
the
come
matter.
back? Don't give those.
Lordship, then kindly fix tomorrow, Lordship. I shall file.
Tomorrow.
Tomorrow,
Alright.
Lordship.
Lordship, day after tomorrow. Tomorrow I will not come, day after tomorrow.
Day after tomorrow. Already. Day after tomorrow. In 11, 12, 3 matters. What is this matter, Mr. Banerjee? What is the grave urgency?
Milord, the urgency is in getting the money. Urgency is in getting the money, which Milord I am entitled getting the money, which Milord
money.
Yes, Milord, which I am entitled to in law, square.
Yes.
And Milord, the urgency is Milord, the client is banging his head on Milord my chambers wall. Milord, that's the urgency. Client is banging his head on my chambers wall. That's the
I am
offense.
for
I
you
can
to overcome that, Mr. Brandon.
That's why I have come to
Overcome
my
that.
lordship.
Babu brought it to the court. Babu brought that trouble to the court.
So that I am saved at the hands.
Yes, sir.
So that I am saved by your lordship from any untoward incident.
Yes,
There are three matters.
state is not involved.
No. State in the sense union is involved.
It is with regard to
Article
the
12.
acquisition by the Metro Railway authorities.
আমি বলবো না আমার মামলাটা
বলো। না,
This is compensation.
No, interest, because of belated payment of compensation under section 8.
Compensation.
compensation paid, Malad. It has been.
अरे बाबा बोलते तो दाओ.
Item number 11, my lord, I have filed my opposition, but no reply has been filed.
Kindly allow me to move the third matter first.
Third matter first.
No, Malad, let our humble submission, Malad.
Hearing and praying for time, your lordship.
All the three matters.
For a week's time, because other two matters are connected, wherein certain appeals had also been filed under RTI, and there's a division bench order which has to be placed before your lordship.
KK commodities, Malad.
For a similar issue.
What is the issue? I have not heard the issue. You are saying similar issue.
My learned friend wanted to place item 3.
All right, Mr. Banerjee, please give a big
Yes.
background because they are saying.
I have been completely hijacked, by a battery of lawyers. Completely hijacked.
You are capable of handling them.
May I just indicate? I had a land. The land was on the bypass. New Godia, Kobi Subhash metro station. I am not very acquainted with the names of the metro stations. I'm told somewhere at Shonarpur. I had a land. The land was acquired.
From 10:30, I am at Kobi Subhash metro station.
Several matters.
Earlier matter.
Kobi Subhash.
Yes. Metro railway acquisition. Orders passed by the competent authority, appellate authority, thereafter.
Kobi Subhash.
Continuing.
I can't say this is the day for a poetic justice, Kobi Subhash. So.
Yes. Yes, so that was acquired.
That was acquired under the 78 Metro Railway Construction Act. The law says.
Before compensation was.
No, it's a little different. Dada ekটু বসুন আমার নালে this law is a little different from the Land Acquisition Act. Land Acquisition Act has a provision for emergency situations. Metro Railways Act does not have it. Metro Railways Act says the moment firstly an intention for declaration for intention to take the land would come. I would file objection. If the objection is rejected, then situation would arise for assessment of compensation. And the land would be declared to have been acquired. The moment that the second declaration comes, the land stands vested in the government, unlike Land Acquisition Act. So since under the 1978 Metro Railways Act, the land automatically stands vested by operation of law. I lose my title as such. I may remain in possession, but to deal with the property goes. Right to deal with the property goes. That's why that act takes care of that situation. The act says if an acquisition takes place under 1978 Act, then possession would not be taken before making payment of compensation. Now, what would happen if possession is taken before compensation is paid? That was nowhere there in the act. The legislature.
What is your problem?
I tell your lordship. Then 2013 Act came. Section 80 provides for interest in two slabs. 9% for the first year, 15% after expiry of first year. A notification was issued by the government. The government made these provisions of 2013 Act applicable to acquisitions.
Section 105.
13 and 15. Section 30 and Section 113.
Of the 2013 Act?
Yes. Those were, no, of the 1978 Act.
Yes, so by virtue of Section 105.
Correct. Of 2013 Act.
Yes.
Yes.
So these provisions.
Notification is under. Yes. I bow down. Yes. My lord knows this. Like the back of my lord's palm. So the notification came. In my case, admittedly, my lord, I say admittedly because there is an admission on record in writing by them. They
Admission
say
of what?
that the possession was taken before payment of compensation. So, my lord, I am entitled to Section 80 interest. My lord, I made an
Section
80 interest under 2013 Act.
So that's the issue.
That's the issue. Now, my lord, an interesting point would arise here. My lord, I anticipate, I just indicate that I am not standing in the way of the prayer for, my lord, adjournment for a week or so. My lord, I just indicate, my lord, just give it, my lord, a bird's eye view, my lord, to your lordship today. সকালবেলা কবিশোর কি হচ্ছে সেটাই কবিশোর মেট্রো স্টেশন জজ সাহেবের ডিটারমিনেশনে লিখতে হবে যে এই ম্যাটার কবিশোর মেট্রো স্টেশন এটা কি কলিউশন? আরে তিনজন মিলে একজনকে হারাবে নাকি? Yes. So, my lord, Section 80 says what would happen if possession is taken before, my lord, payment of compensation. My lord, this provision was made applicable in exercise of power under Section 105 to acquisition under 1970 Act also. My lord, in my case, possession was admittedly taken before, my lord, payment of compensation. Competent
You are
authority.
challenging the award only on the ground that the interest was not granted.
Correct. Now, my lord, I tell you, lordship,
Competent authority has rejected.
rejected.
Appellate authority has also
Did not
rejected.
grant me. Did not reject, did not grant me.
Yes. So
Now, my lord, 2 points.
implied rejection.
Okay. My lord, I bow down. So, my lord, one hurdle I cross. Because, my lord, in other matters, my lord, I was anticipating, my lord, my learned friends or, my lord, my learned friends counterparts were taking, my lord, 2 points principally. That, my lord, I have not claimed it specifically before competent authority. So, I waive my right. My lord, I say that, my lord, Section 80 is not, my lord, an obligation
It's a
to ask
statutory
for.
obligation.
Yes. It's not my obligation to pray for it. It's
Banerjee,
his obligation to pay.
please show me that Section 80 is applicable
Oh,
to 1978 Act.
kindly take, my lord, my brief. Then, my lord, third matter. বসে পড়ো। Kindly take, my lord, the first supplementary affidavit.
All right. Before that, yes, madam. Now that's the issue. That's pending before the larger bench.
Interest component terms of RTI, there was a division bench matter wherein this issue was decided and an order has. I have also not gone through.
Issue decided in what way?
Section 80 applicable.
Section 80 applicable.
Applicable.
Where is the decision? Please.
Your lordship, my learned friend's entire case is based on RTI application and
Maybe
reply.
show me the decision holding that Section 80 is applicable.
So, the decision. Huh?
Let me see. It's only on a point of law. Let me see whether Section 80 is applicable.
Justice Shubhra Ghosh.
No, I'm not on facts. Whether possession taken, not taken, I will come to first. Let me see the application.
My lord, my lord, I was a little wrong. Justice Ghosh, Justice Shubhra Ghosh, my lord, coordinate bench, honorable coordinate bench, my lord, has held it's applicable.
Not the division bench.
No, my lord, from which an appeal has been preferred. My lord, my lord, on the verge of conclusion.
Reference to that, what is the
It's a
number?
unreported judgment.
Maybe. What is the number? Cost title, number, date of the judgment. Please give me so that.
But there is one.
SSA
This
এই সাইটেশনটা
দেখুন তো কোথায় আছে this
এটা নোট কর এটা নোট কর এটা নোট কর
so this is a division bench.
Yes, Miller, this is Miller. I forgot it.
This is on Metro Railways.
Yes, yes. Thank you. I'm a
Show me
copy.
the
Miller, I just take out a copy. But now, Miller, before this, Miller, Honorable Division Bench, a separate matter is being argued, Miller, as regards the applicability of Section 80, which is, Miller, going on.
no section 80 is not held here.
Review na.
Yes, section 80 where it
Miller, I'll just check this. Miller, I'll just check.
yes point number 4.
দিয়ে না বাবা একটা কপি আমি দিয়েছিলি তো এখানেই তো থাকবে সফট কপি দিয়ে কাইন্ডলি মিলট bear with me for a second. My learned junior has made me, Milord, to read, Milord, not less than, Milord, 20 decisions. But, Milord, this traversed up to, Milord, the Honorable Supreme Court also. With regard to, Milord, NHAI Act, which is also a scheduled act, similarly placed under, Milord, the 2013 Act. There, Milord, a decision has been taken.
Has been held.
That's, Milord, this was in review. Slightly marked, Milord.
Which paragraph has held with regard
Milord,
to
may I give your lordship, Milord, a fresh copy? 2019.
so this will help, marked copy will help.
But won't help me, Milord, as this
Oh,
copy is not marked. আমি সব citation
Which
দিলাম।
paragraph says
Yes, Milord. 46 to বসে পড়ো। 46 to 48. হ্যাঁ বলে দিচ্ছি সব দিয়ে দিচ্ছি মিলট 30 31 46 to 48 and 52 এনে কপি নিয়ে NHAI provisions are perimeter. Copy দিন 13 36 দাঁড়া বাবা দাঁড়া 13 31 right 46 to 48 and 52. This is on payment of interest by advocate on record of union.
Mr. Banerjee, in this judgment, which paragraph says with regard to section 80?
Yes. Milord, kindly take 46 onwards.
46?
Yes.
Yes.
You may just. It is worthy of note that even in acquisition that take place under the National Highways Act, Milord, I say similarly placed because comes under the same schedule. And the 1952 Act notification of 2015 under the new Acquisition Act of 2013 makes solatium and interest payable in cases covered by both acts. In fact, with effect from 2015, this is the notification Milord we are referring to. Amendment of ordinance came into effect amending 2013 Act. Section 10 of the amendment says provisions of this act relating to determination of compensation in accordance with first schedule, rehabilitation under the second schedule, and infrastructure amenities under the third schedule shall apply to enactments relating to land acquisition specified in the fourth schedule. So, Milord, this is the provision. It is only when this ordinance lapsed that the notification dated such and such was made under section 13 of the 2013 Act. This notification is important. Milord, the notification which my lord was looking for is, Milord, quoted.
Yes.
Kindly take, Milord, 2-3 paragraphs of, Milord, the preamble or the recital of this notification. Kindly, Milord, take the 4th paragraph of this notification. And whereas 20th, may I, Milord, read this act as 2013 Act.
Yes.
Second ordinance 2015 was promulgated on 30th May 2015 to give continuity to the provisions of such and such. And whereas the replacement bill relating to 2013 Act ordinance of 2015 was referred to in the joint committee of the houses for examination and report. And whereas, as per provisions of Article 1 to 3 of the Constitution, the 2013 Amendment, Second Ordinance 2015 shall lapse on such and such, and thereby placing the landowners at disadvantageous position, resulting in denial of benefits of enhanced compensation and rehabilitation to the cases of land acquisition under 13 Acts specified in the 4th Schedule to 2013 Act as extended to the landowners under the said ordinance. And whereas the central government considers it necessary to extend the benefits available to the landowners under 2013 Act to similarly placed landowners whose lands are acquired under the 13 enactments, which also include Metro Act, specified in the 4th Schedule. And accordingly, the central government, keeping in view the aforesaid difficulties, has decided to extend the beneficial advantage to the landowners and uniformly apply the beneficial provisions of the 2013 Act relating to the determination of compensation and rehabilitation as were applicable to cases of land acquisition under the said enactments in the interest of landowners. Now, therefore, in exercise of powers, the provisions are made applicable by ordinance, because ordinance was going to get lapsed. So, this was a presidential power. It is thus clear, then skipping over the addendum part, it is thus clear that the ordinance as well as the notification have applied the principle contained in Nagpur improvement. Will be relying on that also. As the central government has considered it necessary to extend the benefits available to the landowners generally under the 2013 Act to similarly placed landowners whose lands are acquired under the 13 enactments specified in the 4th Schedule, the National Highways Act being one of the aforesaid enactments. This being the case, it is clear, etc., then. And it goes on. Now, before the Honorable Division bench in another matter, it is being, short to be argued that, it only refers to the schedules, not to Section 80. So, Section 80, cannot get applicable.
Yes, because that is a prima facie reading of those provisions. Please see Section 1053. (1053) says what will be applicable is direct that any provisions of this act relating to determination of compensation in accordance with 1st Schedule and rehabilitation, that is 2nd and 3rd, being shall apply to cases under the enactment specified.
My lord did not take the trouble. This is what was troubling me. I was initially of the view that 1st Schedule, if
without the interest,
stricto sensu apply, then Section 80 does not come to play. That was my first impression, my first take on the matter. Supreme Court in another decision has said that this interest is inherent in compensation, so Section 80 applies. And that opened my eyes.
So that is why in strict sense Section 80 will not apply.
And Supreme Court says it is beneficial legislation. If this is capable of being interpreted in two ways, the interpretation that grants more benefit is to be adopted. This is not a penal legislation where strict interpretation would apply.
Larger bench, it was referred to a larger bench.
No, not to my knowledge. Not to my knowledge.
So please see, this paragraph refers to something.
It has gone up to the curative level. This Tarsem had gone up to. Milord is looking at.
To a larger bench.
Milord is looking at paragraph.
Paragraph 48. Says Chhajuram has been referred to a larger bench. Paragraph, sorry. Yes, paragraph 48, next page. Just before paragraph 49.
I am at there. I am there.
In any case, as I pointed
Oh,
out,
my lord, that was with regard to, my lord, Defense of India rules and, my lord, those, my lord, emperor's notifications.
it's not with regard to anything with
No,
regard to-
no, 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 no. My lord, I can carry Chajjura. I'm sure my lord has come across Chajjura, my lord, in, my lord, cantonment matters.
Yes, yes.
My lord, these had something, my lord, to do with, my lord, those cantonment matters where Defense of India Act and, my lord, emergency provisions, my lord, those things apply.
So this is on national highways, this is also one of those acts which falls within Schedule 4.
Correct.
So the same principles will
Correct.
apply as in these.
So, my lord, that is answered. No more res integra. That was firstly troubling me also, my lord.
After reading those, that
Yes,
section also,
yes. And knowing my lord's mind, my lord, I was a little, my lord, skeptical, my lord, to move this. But, my lord, I satisfied myself first. And now, my lord, I'm confident. It's, my lord, decided.
Your Lordship, before moving to the law point, factually,
division by देखिए पहले नोटा
factually, for the third petition, there is nothing on record from the respondent side. So I need to file a report that I'll do it within a
এই
day.
না না রিপোর্ট দিয়েছিস তোরা
আমি দিন বাকিগুলোতে
তুই দিয়েছিস মানে তুই কিনা জানি না তোর ম্যাটারেই দেওয়া হয়েছে ইটস দেয়ার কিন্তু মানে দ্য রিপোর্ট ওয়াজ বসে পড়ো না please, বাবা The report was affirmed in January 2022 by Deputy Chief Engineer Mr. Uttam Majumdar in this matter, third matter. এই ম্যাটারে দাদা দাদা দেখাবো
আমি তোমার জুনিয়রকে বলেছিলাম স্ক্যান
So here in this matter, here they could not prove that the possession was taken prior to that. That is why factually
may show only one
we
document.
have noted that the amount of compensation was
Paragraph
paid
30,
well before taking possession has not been able to prove that the possession was taken before.
And here, my lord, there is an admission. Here, in this case, there is an
Yes.
which wherein an appeal has been filed. So those records has to be placed. My learned friend, entire case is based on a RTI officer's information.
well, I wonder how can, my lord, they defy their own officer and disown. Can you record this statement?
Yes.
We have photographs.
Photographs will prove what?
That, my lord, possession was taken much before.
With the date.
My lord, satellite images are nowadays available. My lord,
Also advised my client for the satellite image. If
My lord,
possession was taken, we will give
one photograph, my lord, costs 2 lakh rupees. My lord, I tell you, lordship, my lord, one photograph costs, my lord, 2 lakh rupees. And, my lord, if someone is willing to pay that, my lord, I can have, my lord, the photograph of my, my lord, bedroom, my lord, 10 years back with certificate. That is where, my lord, the technology has gone nowadays. আমি জোগাড় করেছি মানে ইভেন তোর বাড়ির ভেতরের ছবি 10 বছর আগেকার 2 লাখ টাকা
যত পিছনে যাবে অত দাম বেশি।
মানে প্রাইভেসি বলে জাস্ট কিছু
Are not distinguishable on facts because here
Absolutely.
here it was
Absolutely.
held that it is
there was no conclusive proof of, my lord, the exact date of possession.
appeared.
Sir, my lord, law of average is now in my favor.
That matter you appear. Yeah, that. Yes, what do you want?
Kindly keep it for coming week Thursday. We shall
Coming week Thursday.
Your Lordship.
Today's Wednesday.
For the vacation.
Workaholic lawyers, my lord, has.
All my learned friends are here who are very sincere. They will all be here.
In my petition, there is no petition has not been represented as of now.
উনি
এই তো
তিনটেতে তুমি বলে যে 3 নম্বরে শুধু
3 নম্বরটা করবো
আচ্ছা,
বলেছি
আচ্ছা,
তুমি ডিব্রিফ করে দেবে নাকি
ওকে
Yes, affidavits have been filed.
in this case yes.
Affidavit in opposition has been filed, my
Hey,
lord.
what's
Where
up?
I have shown, my lord, the payment was made on 6th of November and the land handed over on 16th January 2018.
So after payment of compensation, possession
Well,
handed
sir,
over.
in my case, it is clear.
In your case,
In my case, I'll come with the details. I don't have it.
Well, I filed a report in my case that it was paid prior to taking possession, my lord. Paragraph 8 of my report.
so Have you dealt with those? Because they have, you have also filed your reply.
A reply has been filed to the report.
They have filed the opposition.
Milord, these are Milord supplementary affidavits, copies of which in Milord the third item.
You are in which item?
Second item.
So second item, what happened? You have filed a reply.
Second item, reply hoyni. I need to check. I have not done.
You have filed. You have
So,
filed
Milord,
today.
I've already filed.
Milord, kindly then allow us to come back immediately after vacation. Milord, affidavits in all the matters, Milord, would be exchanged in the meantime.
First item is short done.
Affidavits not in only manner report filed.
The
Reports or affidavits, please
Yes.
file in the meantime. Mr. Banerjee, what are you filing in this?
Milord, these are supplementary affidavits.
Item number 13.
12.
Item number 12 একটা
There are two supplementary affidavits. Milord, these are Milord gradually.
item number 12
My lord, 13, my lord, I appear for the petition.
Yes, read your other side.
My lord, Mr. Snehashi Singh was appearing.
I am appearing on behalf of the port trust, Your Lordship.
My lord, the challenge in the writ petition is one notice dated 12th of February 2026, which my lord will find at page 19 of the writ petition, whereby my lord, the petitioner, who is
The matters are appearing, no.
13,
I directed both these matters to appear, I think.
my lord, one matter.
There is
13.
only one
WPO
matter.
179 of 2025.
My lord, WPO 179 of 2025 is being heard by Justice Aniruddha Ray. My lord, in that matter,
My lord, on the first occasion, our prayer was this, my lord, that we wanted it to be heard analogously, because my lord, the issue which is involved in this writ petition pertains to the land whose present status of ownership is in question, and it
Potra said, you said this has to be heard together.
no.
and they had objected.
I have not
No. There is no direction for analogous hearing of the matter.
No, I have not directed it.
Yes, no.
There was a direction.
Yes, my lord, that was our prayer on the first occasion.
Here, my lord, just before my learned friend proceeds, my lord, I must indicate, my lord, the writ petition has been filed challenging a notice to quit issued by the Port Trust on 12th of February 2026. In that notice to quit, it has been clearly mentioned that if you do not vacate the premises by 31st of March or by 31st of March, you will be considered as unauthorized and proceedings under the PP Act will be undertaken. And that proceedings under the Public Premises Act has already commenced. Section 4 notice has been issued by the estate officer. Hearing has been held. The writ petitioner has participated in the hearing. Show cause notice has been issued and a reply to that show cause has to be filed by the petitioner. My only submission is that this writ petition is not maintainable by reason of the fact that it is a proceedings relating to a public premise. The landlord, that is the Port Trust, good, bad, indifferent, as on date, the tenant cannot question the title of a landlord. They have admittedly paid rents to the Port Trust for all this period of time. Since 1935, they were in occupation. Now, there is an estate proceedings that have been undertaken by the state. My lord, I
Let friend proceed. My lord, because since this is my petition, my lord, let me proceed with the facts first.
Yes.
Because there has been a previous round of litigation. It traversed to Supreme Court, and thereafter, my lord, again a show cause notice was issued. Thereafter, an order was passed. That order.
What is your challenge to the notice? Why are you challenging the notice?
Yes, my lord, kindly comes before coming to the notice to
Proceeding
quit.
has been initiated.
Proceeding
Yes,
initiated,
officer.
lordship.
So,
We came, my lord.
to take all points
Yes,
there.
my lord, we came before my lord. The notice to quit, my lord, purports to override the order dated 10th February, which had apparently held that the land is vested to the state government and which is under challenge before this honorable court in the other writ petition.
Then both these matters have to be heard by the same
My
judge.
lord,
Otherwise, there will be.
my lord, then my lord kindly gives us some protection and let it be heard. And
I am only
that
relying
was
on
the
this
prima facie,
judgment.
my lord,
Now they are trying to basically set the clock back, your lordship. I am only relying on this judgment.
By that bench which is taking up.
My lord,
I am
my
only.
lord, kindly
My lord,
grant
I am.
some protection till my lord.
My lord, I am only.
Don't run at that pace at this age.
But I try to overtake my age every time, but I fail. But I have been a tenant for the last 113 years.
Probably, the last occasion also you have submitted that another proceeding is pending for the coordinator. I think whether analogous or not analogous, both matters have to be heard by the same bench. So,
no, I was.
This matter, I give you liberty because this has to be assigned. Otherwise, you cannot.
But may I just show only 2 pages? Not I prima facie, your lordship was pleased to observe that this can be heard. This matter be heard by your lordship's bench. Please come to page 2 pages, not pages 80 and 81. Not on merit, not otherwise. I will not trouble your lordship. At page 80, paragraph 22.
Yes.
As already stated, the aforesaid land parcel was used by the petitioner, the owner of the land, for various purposes, including construction of storage godowns, road maintenance, as well as allotment of lands and buildings under various leases and licenses. It requires mention that respondent number 4 regularly bills the petitioner for such lands, parcels, and structures. The disputes between occupants of such land parcels or structures and the petitioner are referred to the estate officer of Kolkata Port. But this is Kolkata Port's stand before the other coordinate bench, not insofar as opposing the vesting order is concerned. Now, not I have no not a choice, not but only because not the entire character of the proceedings, not I have to face in a different manner.
That court is that bench is taking up.
Yes, not
better if both these matters because.
Not I had mentioned this not matter not when I tried to move it. Not I had mentioned that this was the predicament which.
Yes, you have said that. I think I'm noting that I am.
Now, but today the predicament is not the matter has been fixed in June, if I am not wrong.
Just one point I must indicate, your lordship. The estate officer is already in scene of the matter.
Let it not proceed for the time being.
I am only relying on this judgment of the coordinate bench, your lordship, division bench judgment. My lord, if a section 9 proceedings, if a proceedings under the Public Premises Eviction of Unauthorized Occupants Act has been initiated, office copy.
So there may be two things. One is if I have to go to this, then I have to consider the merits. Or because one proceeding is there, without going into that, I can release this for being heard by that because it has to be assigned. It
So,
should not be directly.
That proceedings under the Sheets Act, what is being contested by the port, that particular notification has been stayed, and there is an order passed on the last occasion by the other bench, my lord.
That is why I'm saying let that bench consider both this.
My lord, these proceedings will be stalled, my lord.
Kindly,
The only option
the
for them
predicament
is
is
to
this:
take
the other.
steps.
I can't approach the other bench before June.
That is the other matter. You can get your chance. I can release this matter today so that you can take a chance if it is assigned.
Yes, because his lordship is now in the circuit bench.
My lord, they are to reply to the show cause, my lord. It is not yet decided whether they are unauthorized.
Not Monday, not 2 days given in 7 days span.
18 June, my lord. Time to file reply. No, 18th May, your lordship. Time to file reply to the show cause.
Kindly permits us to pray for adjournment. That's all.
Given an opportunity to file a reply to the show cause.
Why they will disclose their stand there? They will not because they have challenged this notice.
My lord, they have challenged a notice to quit, your lordship.
I'm staying that proceedings till the June.
My lord.
Releasing this, let these both matters be heard together.
Actually, অসুবিধা কি আছে তো বিয়ে হয়ে যাবে না
After June,
ফার্স্টে বললাম তুই অপোজ করলি
how long they are in occupation?
135 years.
Then
1935 থেকে আছে।
এটা আচ্ছা Almost 113 years.
91 years, your lordship. 91 years they're in possession.
91 years.
You cannot wait till June. If you say that you will not proceed, I record that. I am not passing any interim order there. I am releasing this. If you give an assurance that.
My lord, I'll only request you, lordship, my lord, what has fell from your lordship, my lord, kindly keep the matter tomorrow. Kindly let me take instructions on the proceedings before the estate officer. Let me come back, my lord. Yes, your lordship. May it be as to be mentioned as well, my lord. Let me take instructions.
being severely reprimanded, and I admonished myself
Yes,
for
what
doing this.
happened?
Your Lordship would recall Mr. Orindo Banerjee was moving item number 6. Mr. Banerjee was appearing virtually. He had indicated we have also filed a writ assailing the UD license that has been
No,
revoked.
I've not. I've said that you are contemplating to file a writ
No,
petition.
we it was ready with us.
Yes.
We couldn't file it by morning. Your Lordship has, perhaps I'm informed, has kept the matter on Friday. The only difficulty is, Your Lordship, without Your Lordship's leave of short service and Your Lordship's leave, we won't be able to file it with the department, and it won't be listed within 48 hours. So I have informed Mr. Orindo Banerjee also.
Please give a copy, serve a copy upon
Yes,
the,
yes, of course, of course.
upon Mr. Banerjee as well as Mr.
All parties will do that.
Yes, respondent authorities you serve. In addition, you serve upon Mr. Dhiraj Trivedi.
In fact, they are parties to my writ application also. So in any event, I will have to serve them. Only leave I'm seeking is for short service.
Serve upon the authorities. In addition to that, you serve upon.
Yes, personally on Mr. Trivedi and Mr. Banerjee, as also on the authorities by will do. Huh. Will do. I'm so grateful to you.
Yes. Yes.
Number 14.
Passover. You are appearing. Passover.
Item number 15, 16, 17, 18, 19, 20, 21, 22, 23, 26, and 24, 25, 26, 27, 28, 29, 30, 31, 32, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 54, 55, 56, 57, 58, 59, 60, 54, 65, 71, 72, 73, 75, 76, 77, 89, 81, 82, 85, 86, 89, 90, 91, 92, 93, 94, 95, 96, 100, 101, 102, 103, 104, 105, 106, 107, 108, 109, 110, 111, 112, 113, 114, 115, 117, 118, 121, 125, 126, 128, 129, 130, 131, 133, 134, 135, 136, 137, 138, 139, 140, 143, 144, 145, 147, 148, 149, 150, 151, 152, 153, 154, 155, 156, 158, 159, 160, 161, 164, 165,
42, Malad, the other side is Union of India, Malad.
You are not there. What can be done?
Petitioner is also Malad.
They'll appear. Wanted to inquire that who is the compensating giving authority. they are not present, so it's muted.
Who is the authority?
My lord, I have gone through the railway. My lord, here it says competent authority under the central government railway. My lord, that has to be the general manager.
General manager.
Yes, ma'am, because it does not specify as to who is the concerned authority.
Show me the provision.
My lord,
20H1. Specific 20 start from 20, but 20H, my lord.
Who has been appointed as the competent authority? Where is the notification?
My lord, in this matter, Mr. Ajay Gaggar is appearing on behalf of the Union of India, my lord.
Yes. Who is the authority? Competent authority for compensation?
My lord, the competent authority have the notification.
General manager.
It's the Deputy Chief Engineer, Land Garden, Southeastern Railway, my lord. I have the notification. My lord, kindly keeps it not today.
Division.
I'll give you a copy of the notification. Second.
Right. Give a copy of this notification
my
to
lord.
your learned friend.
Yes, ma'am.
Dear.
My lord is keeping it not today.
I 20 also Eastern Railway is answering respondent, my lord.
Union is also not appearing. State is not appearing.
My lord, my lord, the concerned party, my lord, authority is part, but in the prayer portion, I have made prayer that let it be considered by the general manager.
General manager.
Yes.
That is why I asked you, there is a notification.
But on the last occasion, I have provided my lord a judgment that has been passed by a coordinate bench. My lord, if my lord recalls, that the direction was upon the general manager.
Not because
Yes, my lord.
notification, this is the authority. If the direction is passed upon a different authority, it will be difficult. That is why I asked you to inquire who is the authority. Unless direction is passed upon that appropriate authority, it might be difficult.